All please rise. Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals held in and for the State of New York may now draw near, give their attendance, and they will be heard. Please be seated.
Good afternoon. Before we start, I wanted to welcome students from the Constitutional Law class of Professor Richard Keister at SUNY Delhi. Welcome. I understand you're particularly interested in issues of criminal law and search and seizure, and unfortunately, the first three cases today are civil cases, but we do have a criminal case for you at the end. So welcome. Thanks for coming. First case on the calendar is matter of claim of Klosterman and several others. Counsel?
Just 1 minute, Judge. I just want to adjust this.
Of course. Take your time.
Good afternoon. May it please the court. I'd like to reserve about 5 minutes for rebuttal, Your Honor.
Yes.
The Third Department below held that a worker's entitlement to federally provided COVID benefits, which is intended to supplement to help workers who were out of work, lost earnings because of the COVID-19, and were not eligible for state unemployment benefits. That entitlement now, according to the state and the Department of Labor, is also largely governed, if not entirely, by state law. And state law now can impose additional requirements to condition the receipt of federal benefits. Now, the basis for that contention, which was accepted by the Third Department, was not statutory authorization by the feds. The federal statute is absolutely silent about allowing the states to determine eligibility.
But under regular federal unemployment, the feds do defer to the states to figure out how it should be meted out. Isn't that right? So why should it be any different here?
There's a difference between eligibility and processing, Your Honor. And I think that's what the Third Department got wrong. What the Federal CARES Act did is set up eligibility for these benefits. Then they work in tandem with the state. We're going to give you the money to the state. State, you now process them, not determine eligibility. There's nothing to indicate that the intent of Congress.
But the CARES Act, there was no definitional terms there. They didn't define anything. If we agreed with you and it got sent back, what would happen? You'd apply the CARES Act, and what kind of standard would they apply?
I'm not following your question, Your Honor, because I think it's no statutory interpretation. The issue here is, are they covered individuals?
And
if you're a covered individual, you're entitled to benefits.
And what does the CARES Act say? Who's covered?
The CARES Act says you're ineligible for unemployment benefits on the state. They're not ineligible. The state has made that clear. Second, they are unable to work due to the inability, the closed workplace due to COVID. And that's it.
Does the federal statute or regulations define what that means?
What means, Your Honor?
What it means to be unemployed or partially unemployed or unable to work because your place of employment is closed?
I don't think there's need for definitions on that, Your Honor. It's just Webster's plain meaning. Inability to work.
Well, what would be partial unemployment? I work 1 day, I work 1 hour?
I don't know the answer to that, Your Honor. I'd have to look at what there may be something in the federal regulations that say that. That's not an issue in this case. And I honestly just don't know the answer, and I'm not even going to guess on that.
You say that's not an issue in this case because your clients are not saying they were partially unemployed.
No, we're not arguing that at all.
Okay.
We've argued from day one at the ALJ always that the pandemic, that we come within the covered individual, we were unable to work because the workplace was shut down. Their workplace being the ability to now provide the educational, instructional services that they had been providing.
But they didn't have a contract that they had signed or a firm offer, did they?
No, Your Honor.
So just in a colloquial sense, in what way were they unemployed, given that they had a full-time job and were getting a salary based on that full-time employment?
Well, in essence, Your Honor, and I think I'll answer your question by saying this. Their summer employment was a second job.
But
We
it
do-
wasn't
no-
guaranteed, was it?
No.
So if I have a hope that I will pick up some additional hours, but I don't have an offer and I haven't, signed any contract or entered into any oral agreement, why doesn't that difference matter in terms of whether they're unemployed?
The way this case was structured, Your Honor, and the argument that you're making was not raised by the state at all. The point is here, and this is
You're
why we
asking
have,
us-
this is why we have 6 cases. The basis was that the first group, that we have 475 docks workers. The vast majority of them always had worked in previous summers,
I understand, but what I'm asking is,
but there's no contract.
I understand, and no offer that had been extended. Suppose, the location wasn't operating for some other reason, maybe they lost funding or something like that. I mean, there's some contingency that's at play, it seems to me, in terms of whether there will be a job available, and separately, they otherwise have full-time employment. So I'm trying to understand in what meaningful sense they're unemployed, totally unemployed.
Are you looking at the state definition of totally unemployed?
Well, I'm asking you that
Okay.
question. in
Well,
what
totally
sense?
unemployed means under 590 of the labor law, you're not working at all. You're getting no second job, no third job, nothing.
Right.
That's not the requirement in COVID.
But they do have a full-time job, and I take it that what the argument is that this additional position, which they would like to obtain, is no longer available.
Exactly, Your Honor.
Okay, and so I'm just asking, how does that constitute total unemployment? Maybe
We're not
talking,
arguing total unemployment.
Maybe we're,
No, I think here,
No.
it would, remember, there are alternatives: total unemployment, partial unemployment, or inability to work due to a COVID.
okay, and so you're relying only on the third, then?
Exactly, Your
Unable,
Honor.
okay.
We're not relying on totally unemployed, we're not relying on partial.
And so your argument is that the CARES Act spells out they're not otherwise eligible, and as long as they fit within one of these specified persons as unemployed or partially, they're covered. Would you argue that the state is simply the conduit for the payments, that they don't get to define who gets them?
Exactly, Your Honor. In fact, I think the instructional letters that the state relies on, that the third department cited, made clear that the whole system was set up by Congress. We have an emergency situation, the pandemic, and we want to get money to workers who need the money who are not working.
Yeah, but that's the crux of the issue. Who are the workers who are going to get the money? So if the CARES Act is tied and tracks the state law, and there is no definition, as Judge Singas has already pointed out, to the 3 categories: unemployed, partially unemployed, or unable or unavailable to work because of, et cetera, et cetera. There's no definition for that in the federal statute or the regs. Where does one look to figure out whether or not the worker who's seeking these benefits is eligible?
I think the statute, the language is clear. There's no
What,
ambiguity.
well, okay, I asked you what's partially unemployed, and you couldn't give me an answer. You said I have to go and look at the regs.
I can't answer the total unemployment, Your Honor. I don't know if it's specified. I just don't know the answer to that. And
Well, then why is the category you rely on specified? What's so obvious about unable or unavailable to work? What does unavailable to work?
unavailable or inability.
No, it says unable or unavailable to work.
9021 talks about the individual's place of employment is closed as a direct result of the COVID. He's unable or unavailable to work, unable to work. You can't work if the place of employment is closed.
So
But that would be almost everybody. But that's not what it means. It can't be that in and of itself.
I would disagree with you, Your Honor. I think the language here is clear.
What if you've got a job somewhere else?
That may be something different.
But
again,
if
what
I
we're
have a
doing here.
full-time job as a music teacher at a school, full-time, I'm getting my full salary, but I like to give music lessons on the side on the weekends, but I can't do that anymore because of COVID and nobody wants me in their home. You're saying I'm unemployed for CARES Act purposes?
For the lost, yes, for the lost wages that you can't make on your weekend jobs.
So everyone who has a full-time job that misses out on getting a second job or getting additional income, you think is eligible for CARES Act relief?
That's what Congress intended.
So let me-
Congress did not say, well, if you have a second job, you required a second job because.
What
I
if
need
it's an
to-
individual who does not, I'm over here, regularly work at the second job? Sometimes they do, sometimes they don't, of their own choice.
Well, here, the record in this case, Your Honor, is that they had worked every summer for the past
I'm
several
asking
years.
you a hypothetical, because we're trying to figure out the definition.
I'm sorry, what?
I'm asking you a hypothetical, though.
I
What if it's a
honestly-
worker that does not work that second job regularly? Let's take an instructor
Well,
like this who works one summer and then takes off the next summer.
That would be a different, that'd be obviously a different situation, but
But how
I
would
think
they
my
fit
answer.
within the CARES Act?
The CARES Act simply says any covered individual. So left open in that regard, anyone who now has a second job, third job, and they've lost that second or third job.
So what
Now,
would you, what would you,
again, we
what would you?
agree that they're getting money for the whole year.
What would you do in this circumstance? I'm a junior in college. My freshman and sophomore years after college, I came home, I looked for jobs, I got work each summer. I'm planning to do that after my junior year. COVID hits in March, and now I can't apply for a summer job, although I've had one every summer for the last several years at different places. Am I covered, not covered?
Well, obviously, it's a different situation what we have here.
Right.
I think on your case, probably not covered.
Why?
Because I mean, your first time, you had, unless you had a real assurance, say as Judge Callaghan was getting at, it was the contract.
So there's an exemption for
We don't,
first?
obviously, it could be abused. Well, gee, maybe I can get some free money here. I'll say now I wanted to get a job, but I didn't.
Sounds like you're resting, over here, sounds like you're resting this on a unilateral expectation. In other words, I've worked there the past couple of years, however many, 2, 5, I don't know how many we'd have to decide. And so I have an expectation that I'll be able to come back the next summer. But you're, I think, telling the chief that if I haven't worked there every summer, I don't have a claim? How, what's
Yes,
the rule
I
that,
think that's-
well, what's the rule you're asking for? Who's in and who's out?
If you have an expectation, and because you've been doing it in the past,
For 1 year, 2 years, 5 years? Doesn't,
well, to answer your question, Your Honor, the reason why we have 6 appeals.
no, but we're trying to figure out what a rule would be that could be applied, I think,
I think here, if you've worked in the past 2, 3 years,
but not 1 year.
1 year,
Okay.
and you did it before, again, reason why I say that is the statute says any individual. It
Counsel,
doesn't talk about
what
that.
is it about the CARES Act that dictates that result? Because, you know, as we've all recognized, it doesn't say a lot. It just says unemployed, underemployed, et cetera. So why is there a difference between someone who's worked every summer for the last 6 summers and someone who just decides in, I don't know, January of 2020, oh, I'm going to go do that work this summer? Why is it that you say there's a
I think, first of all, it's a clear-cut case if they've been done it before. With the mere expectation that, gee, I want to try it for the first time.
But you seem to suggest that you wouldn't be able to do it if you had never done the work before. There's something significant in your mind, or so I understood, to the fact that they had a history of doing this before. And I'm just wondering if there's anything in the CARES Act itself that leads you to that conclusion.
No, I think what leads me to the conclusion is that, again, the language is a covered individual is quite broad. Now, what we're
So
saying
it could
here-
be a first-time worker. It could be the person who just says in January 2020, you know what, I'm going to do some summer school at Doc's this summer.
I agree. You don't have to reach that, you don't have to address that issue in this case, though. That'd be a different case. What I'm suggesting, and I'm going out on a limb, if maybe there is an expectation, that would be covered. The key is, Your Honor, the public policy of the CARES Act. If you're out of work, we want to get money to you, especially if you're not getting money from the state. In fact, it's very interesting is the state now is trying to nullify that. Why would the state now, it's not the state's money, it's not the employer's money. Why is the state now saying that you have to be totally unemployed when they're not working? And the whole intent of Congress was get money into these people's pockets. And the state is frustrating that. Now, whether it's a second job or a third job, I don't think it makes any difference. Again, a lot of people in this economy are working a second and third job to make ends meet. So yes, they're getting their salary Judge Singas was getting at for the music teacher for an entire year. But that 1 year salary doesn't work. They need extra money. So it's that second job that's being covered. And there's nothing in the CARES Act that precludes any coverage for that. And certainly in that respect, if you point out now to the, I'm sorry to make just one more minute, Your Honor.
Go ahead.
If you point out the state relies on, the third department relied upon these program letters. The program letters have nothing to do with eligibility. The program letters said provide states with guidance for reporting financial instructions, work in tandem. All we want the states to do is to process the darn claims. You have the infrastructure. We feds are not going to set up a separate structure. We're going to rely upon you. And the state of New York agreed. This was not mandated. Every state had the option to say, oh, we're not going to go along with this. New York jumped in. And as we point out in my reply brief, with the Helvering case, once you now accept federal benefits, and you agree to the conditions. You now can't say, oh, no, we didn't do that. Unless there's specification for that. And there's nothing in the CARES Act that allows the states to say, you know what, you've got to still be totally unemployed.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Brian Lusignan with the Office of the Attorney General, representing the Commissioner of Labor.
What is the state's authority that, despite the verbiage of the CARES Act, that total unemployment is required?
The CARES Act is silent as to what it means to be unemployed, partially unemployed, or unable or unavailable to work. Instead, the CARES Act, when Congress enacted the CARES Act, it relied on the existing federal-state unemployment system, and under that system, states generally define the eligibility requirements for unemployment.
But it also starts out with not eligible for regular compensation or extended benefits under state or federal law. It begins with you're not otherwise eligible, and then it goes on that you can't for the partially or totally because of COVID. So aren't they setting out what the parameters are? Yes, normally you wouldn't get the money, but under CARES, the object is we want that money going to people.
Yes, Your Honor. In general, that's correct. What Congress did, though, was they expanded eligibility in certain specific ways. So, for instance, generally under state laws, individuals who lack an attachment to the labor market are ineligible for unemployment. Under the CARES Act, those individuals were eligible. This includes independent contractors. A college student, to go back to one of the hypotheticals, a college student who had a firm offer, a bona fide offer from an employer to start after they graduated from college in 2020, who then lost their job because of COVID, they wouldn't have the work history to generally qualify for unemployment, but that individual under the CARES Act would be qualified to receive unemployment.
So under your reading, what meaning do the words partial unemployment have with respect to New York? It looked to me that there are, the Senate memorandum suggested that there are at least a few other states that do allow for coverage of partial unemployment. Does it just have no purchase as to New York State?
No, Your Honor. At the time in question, of course, this has all changed, but in 2020, the concept of total unemployment is measured on a day-by-day basis. So the concept of total unemployment captures traditionally what we would think of as someone who's unemployed. They stay home 7 days a week and don't make any money. It also captures folks who are partially unemployed in the sense that they work up to 3 days a week. They can work and still receive unemployment because they were totally unemployed
And
on
if
4 days of the
instead
week.
your hours are cut from 7.5 to 3, you're, I take it, not partially unemployed under your reading.
If
Is
you
that right?
worked 3 hours on a day, that day would not count towards your benefits.
Right.
But if you were totally unemployed on 4 or more days of the week, you would be eligible for
Okay,
benefits.
so you're saying that the words in the federal statute still have some meaning under your reading of the law and under New York law because total unemployment may subsume what we might think of as a practical matter as partial unemployment. Is that right?
Correct, Your Honor. And it subsumes as well the unable to work prong.
And who then gets the benefits available under the CARES Act in New York State? Who is covered?
Individuals who were independent contractors traditionally wouldn't have an employer. They wouldn't be eligible for unemployment under the CARES Act. They were covered.
Presumably the
Individual-
totally unemployed.
If they have 4 or more days of total unemployment in a given week,
And is the
yes.
notion that at some point their benefits would run out and this would extend them, or how would it benefit somebody who is totally unemployed?
That's another category, is folks who have used up all their state benefits would be ineligible for further coverage, but under the CARES Act, they would get those federal benefits.
And why not these people? What's the distinction?
The distinction is that these individuals received an annual salary for 10 months of work, and the state by contract and by statute cannot require them to work in the summer. They have to pay them additional, an hourly wage if they're asking them to work during the
And
summer.
what if we view this as supplemental employment, a second job, or like Judge Singas's hypothetical, someone who has a job, but they also have some weekend work that they do? Sounds conceptually similar to that.
It is conceptually similar to that, and Congress did not intend to cover that aspect. Congress intended to
that.
cover folks who lost.
How do we know that? I mean, I take it, if, under your reading, then, even if someone had signed a contract for a second job, they wouldn't be covered.
That's
For that
correct, Your
second
Honor. If they
job.
had a primary job that they were still receiving their full
Right.
salary
So-
for.
So what can you point us to confirm that that's not what Congress meant, was to cover the second job?
Sure. So one piece of evidence is not conclusive, but Congress in the CARES Act said that individuals who could telework with pay or who received paid leave benefits, like paid sick leave, are not eligible for CARES Act benefits. That suggests that you have to have actually lost income. The fact that you're unable to work in the sense that you're at home isn't enough to qualify.
Saying there's no way to show loss of income when it's a second job?
It's a loss of income, but there's no days of total unemployment. These folks were being paid an annual salary. There's also evidence.
Essentially, for you, really what it comes down to is, regardless of how they get paid, although I think many of these petitioners were getting paid 12 months out of the year, even though they were only working 9 months out of the year, or reporting to work 9 months out of the year, that precludes them from a recovery under the CARES Act, even if they previously were able to do other things with that time. Is that
Correct,
how
Your
it-
Honor. Yes.
And so it's all keyed to their status as full-time employees.
The CARES Act does not cover second jobs. It does not cover overtime that you might have had an expectation to make prior to the COVID-19 pandemic. I'll give you some
And the way you
additional-
know that, because I think that this was the question you were just asked.
Yep.
The way you know that is because of sick time provisions?
That's one piece of evidence that Congress didn't intend this coverage to include individuals who are making their
I'm
full
not sure
salary.
I follow that. You're saying if, we maybe run through that again, because it didn't make sense to me.
Sure. So under Section 9021 A3B, Congress specifically said, just because you are not going to work, if you're at home, if you're getting paid to telework, or if you're getting sick leave,
Yeah.
you're not included
But
under
how
the
does
CARES
that
Act.
show that a second job is not covered? That
It's
it's a
one-
connection I don't understand.
It's a piece of evidence that Congress was talking about
Your
loss
main
of your salary, of your full-time salary. And there's additional evidence I can give you from these Department of Labor program letters. Now, under Section 9032 of the CARES Act, Congress specifically authorized the Department of Labor to issue operating instructions. This is how the Department of Labor tells the states to comply with the CARES Act, how the department tells the state to comply with a general federal unemployment scheme. In those letters, you can look at 1620, change 5 at page 4, An individual who continues to receive their full pay is not eligible for CARES Act benefits. A teacher in a traditional educational program with a reasonable assurance of return to work at the end of the summer is not eligible. That's in Program Letter 1620, Change 5 at page 7, as well as several additional of those program letters. An individual who cannot find a job because businesses are closed due to COVID. Under Program Letter 1622, the Department of Labor said that's not covered under the CARES Act. And even under subdivision KK, which is the subdivision that claimants here are relying on, any individual who's working reduced hours while her place of employment continues to operate is generally not covered by that subdivision KK, although they may be covered by another provision of the CARES Act. So folks who are covered, according to the Department of Labor, which again is responsible for approving the state's agreement with the federal government and telling the states how to comply with the CARES Act. Folks who are covered are self-employed, freelance writers, independent contractors who experience a significant diminution in their work, individuals caring for members of their household whose ability to perform other work functions is severely limited, and an individual who has their hours reduced or has been laid off due to COVID. These are all in these program letters. So again, I don't know that you need to go to the program letters because the statute itself is silent and is kind of built on top of this existing federal state unemployment program. But the Department of Labor has repeatedly told states that individuals who are making their full annual salary don't qualify for CARES Act coverage. And I want to talk a little bit specifically about the unable to work prong of the CARES Act. There's a couple examples of individuals being unable to work that the Department of Labor has referenced. There's an individual who has to stay at home because they've contracted COVID or someone in their family has contracted COVID. There's also individuals who have to stay at home to take care of a child whose school is closed due to COVID. And in those situations, the individual would be unable to work in the sense of they can't go to their office, but they're not unemployed in the traditional sense of having lost their job and involuntarily. The CARES Act covers those individuals. Those individuals, though, would also have experienced days of total unemployment. That is, when they're staying home with their kid or with their sick relative or recovering themselves, they have days when they don't go into the office, they don't get paid, and therefore they are covered under the CARES Act.
Just to be clear, if they were working remotely and being paid, they would not be covered? The
That's
parent,
correct.
The example of the parent.
That's correct, and there's some guidance letters about this saying if your kids are so unruly that you can't get your normal job duties done while you're at home, you may be unemployed. But if you're teleworking with pay while you're kind of keeping an eye on the kids, as many of us did, then you're not covered by the CARES Act. And I don't want to minimize the harm that these claimants endured during this period. Many of them testified that they relied on the supplemental summer income, but that's just not what the CARES Act gets at with these unemployment provisions. There were federal stimulus checks that were sent out to virtually everyone to try to account for some of that economic collateral damage, but the CARES Act itself just doesn't cover those individuals and doesn't supplant existing state law, including in New York in 2020, the total unemployment requirement.
Is a minimum salary a factor at all?
In New York, it comes into play if an individual is partially unemployed in the sense of being totally unemployed on fewer than 7 days a week, which is to say, if you work 2 or 3 days, 1 day a week, but you make over a certain threshold on those days, then you're not eligible for unemployment benefits. But at the time,
That seems to be some of the problem here, because total unemployment is just a misnomer, and maybe it would be helpful to find another word for that, because you can still get benefits if you can still be considered totally unemployed if you're partially employed.
That's correct, Your Honor. And the state legislature did change that program, so you may not have to hear about total unemployment again, but it is used not in a intuitive manner.
Yes.
And much of the unemployment law is not intuitive, although I think the outcome here is fairly intuitive, which is individuals receiving their full annual salary are not eligible for unemployment benefits.
So just to be clear, looking at the CARES Act provision that we're most concerned with here, the first part is about eligibility, individual is not eligible to receive state unemployment benefits, and the second part that does refer to unemployed, partially unemployed, or unable or unavailable to work, your position is that is still based on how the state would define those things, correct?
Correct. In the absence of anything in the CARES Act specifically expanding the eligibility or removing a
As
disqualification.
in the enumerated COVID-related reasons?
Correct,
Which
Your
is
Honor.
specific to the CARES Act?
Yes.
Okay. So that might differ across jurisdictions?
Correct, Your Honor.
So the CARES Act doesn't have a uniform criteria then?
That's correct. There's 50 states, there's 50 different unemployment systems. They all work a little bit differently, although they share certain features.
So it might be possible then for someone who, New York would say, you're not eligible for the CARES Act, that New Jersey might say you are eligible for the benefits under the CARES Act, that are similar otherwise?
That's correct, Your Honor. Similarly situated individuals might be eligible in one state, but not in New York.
And do you know if any other states are all the states using their own definitions? Has any state said no, like go back to USDOL and try to figure out what these terms mean?
Not as far as I'm aware, Your Honor. Our brief cites several state cases that have applied state law to CARES Act claims. None are directly applicable to this specific situation, but I am aware of no state case in which a state said the federal law establishes the full scope of coverage, and we're just going to look at the federal law and apply those plain terms. Unless Your Honors have any further questions, I would ask that you affirm the third department in these cases.
Thank you.
Thank you, Your Honors.
Initially, I stressed, and what Judge Troutman was getting at, there are three options here: total unemployed, partial unemployed, inability to work. We're simply dealing with the inability. And what was just asked by Judge Singas about other states. Other states are not cited in my brief because I didn't think I had to. But if you do put in the CARES Act, you'll see that all these other states that have had issues like this have simply said, are you a covered individual? And leave it at that.
But do they do that,
Precisely at those
counsel?
three language of the
But how do they define a covered individual? Where do they get that definition from?
9021A1.
But I feel like that's circular.
I honestly don't, I honestly respectfully disagree with you, Your Honor. I think that statute is quite clear, and other state courts have said that same. Now, the other thing, too, I get at, and what Judge Halligan raised about, the individuals. What's interesting is the example of the gig employee can't get unemployment. He's an independent contractor. Under their reading is that, well, he's not eligible, can't get in, but what the legislative history of the CARES Act clearly indicated, we want those people who can't get unemployment benefits to get our federal benefits. And then lastly, and again, that's what I was getting at, trying to get at you with Judge Halligan, but I think you thought I was maybe trying to avoid you, but I wasn't. With respect to the expectations, there are six cases here. Why 6 cases? Well, the first 4 are based on their test cases. What they're based upon is how many years those employees had been working, summers. And so the first group, Alamindo, they go back to 2012. The second group, I think, went back about 4 years. And then the last 2 were individuals that didn't get into that. But all that now bears forth, and what's clear is, if you take a look at what I'm saying, Your Honor, in each of the appendices, right before the last page, right before the additional papers of the Court of Appeals, there's the stipulation that everyone entered into. And if you look at 6C, paragraph 6C of that stipulation, it specifies the who's been working. So this case has been tried solely on the expectation. I had it in the past, I'm going to do it now. And again, there's no contractual, but no one's ever argued, the state has never argued that mere expectations alone is insufficient.
So unable or unavailable to work has to be because of one of the, or more, of the enumerated reasons in the federal statute,
Correct.
right? So which one or ones fit your clients?
Double J.
Just double J?
The place of employment is closed due to COVID.
Okay.
And the state
and
now
so-
tries to respond by saying, well, it really
So
wasn't
that-
closed.
Then that raises the question of when does somebody have a place of employment?
Well, that would be a question of interpretation. Yes, Your Honor.
Right.
And our argument is that,
And
well,
if you look, for example, at GG, the individual is scheduled to commence employment and doesn't have a job or is unable to reach the job, which implies that if you weren't scheduled to commence employment, maybe you don't have a place of employment.
that's, again, but it's a separate category.
It is, but maybe that informs us about how to read, how to interpret JJ.
I would, to the extent that you're suggesting that it may inform the definition of place of employment, I would respectfully disagree. I think there's separate, discrete categories. And the place of employment that we're saying is, and had not yet really been argued at all, the state argues it a little bit in their brief, is that, well, is his place of employment really closed? Well, the facility's not shut down.
Did they work at the
But
same?
the facilities where the educational was were shut down.
Did they work
That's his
at-
place of
did they-
employment.
Did each of them work at the same prison every year, or did they go from prison to prison?
I'm not sure. My understanding, and I can't vouch for this, Your Honor, I think they all worked at this, they kept on working at the same facility. That they didn't travel around and go to different facilities.
Thank you.
Thank you, Your Honors.
Next case on the calendar is Matter of Mantilla versus New York City Department of Housing Preservation.
Good afternoon, Your Honors. Dennis Fan on behalf of Kermit Mantilla. When Kermit came to New York to care for his dying brother, Ray, he applied for Medicaid, food stamps, and home energy benefits so that he could afford to live here.
Counsel,
And
what's the standard of review that we're applying here?
So I think you are on an arbitrary and capricious standard review for an Article 78 case. And I want to point out, I think, the two most arbitrary pieces of what HPD's decision are. So the first thing is, HPD said that it could sort of summarily discount information before March 2019. And that's arbitrary for a couple of different reasons. But the second thing is HPD also did not reasonably conclude, but unreasonably concluded that Kermit was somehow able to visit or was coming back and forth from Florida to New York, in fact, lived in Florida. And that was part of HPD's determination.
Can
as
you
well.
go back to the first one? What's inherently arbitrary about HPD wanting to focus on the window
So
period?
there's two things that are really arbitrary about that. First is I don't think there's anything inherently arbitrary, but what HPD said was, look, we have a Social Security letter that is mailed to you or has a Florida address on it that's before the window, and we're going to count that against you. But in fact, you have also SNAP letters, HEAP letters, Medicaid letters to you from that exact same month, February 2019.
Is there an explanation as to why they're treated differently?
There is no explanation of why they're treated differently, and that's what this court's case law says. If you make a determination on essentially the same type of facts and you do it a different way, you at least need to have some sort of reasonable explanation. So it would be one thing entirely if HPD came to the table and they said, look, I don't want to look at this entire body of evidence from before the one-year period, and I don't want to look at it because I actually think it's really messy and it doesn't really tell us very much. But then you can't hold that exact same type of document against somebody who's applying for benefits, and that's fundamentally what's arbitrary.
So you're not arguing that they must look at the pre-period information. It's just if they are, then they have to look at what might actually be also favorable
Especially
to
if
the
they come in
claimant.
the exact same month, and especially for this Social Security letter, when you know, based on when he got a different document in his income recertification notarized, that he actually was in New York during that period. The fact that you have a mailing address on a document
Well, the
doesn't
point is
mean-
whether or not it's his primary residence, right? One could be in New York. One could be caretaking for a very, very sick relative.
I think that's right. One can be in different places. One can have multiple residencies. But what the main point is if you have all of your HEAP benefits come in February 2019, your SNAP benefits, your Medicaid benefits come in February 2019, and what HPD says
Well, that's because
is,
he's present in New York.
Well, right. I
So
mean,
we're back to the
yeah, you have
question,
to.
is presence alone going to get you primary residence?
I don't think presence alone will get you primary residence. I think what Kermit also has is a whole bunch of leasing documents, right? I'm not going to call them leases, but he has leasing documents where he has actually put himself onto income recertifications, which he has to do. That's a kind of fundamental feature of being an occupant in a home. It makes their rent go up. I mean, it means that part of his $850 Social Security paycheck that he's trying to live in New York on is now being called by Manhattan Plaza. And that's something that it's fairly irrational to think that somebody who lives on Social Security alone is going to send off a third or 30% of their paycheck to not live in New York.
Well, again, it's whether or not it's the primary residence, right?
Yeah, I mean, I think that
Merely
is right.
living, or do you think that living in the apartment satisfies primary residence?
Yeah, I think living in the apartment, having benefits in New York, those things together satisfy what I think of would be primary residence. And there's definitely a rational basis for HPD to make the exact sort of opposite decision.
Do the applications for the benefits that you're talking about require the individual to swear that the address they're giving is their primary residence?
I mean, I think that is the fundamental sort of premise of an application for succession rights, is they're saying, look, this is
No,
my
not the
primary.
succession rights, the SNAP benefits, that kind of thing.
Yeah, you do need to swear that they are your residents. In fact, if you're
That they're
if
your
you're-
residence or your primary residence?
I guess, let me put it this way, like, these things operate a little bit differently, right? So like Medicaid, for instance, if you have emergency health services out of state, you can still use your New York Medicaid, you can go to the ER out of state, but you can't get, for instance, your diabetes medication. So it would be a very strange thing to think that you had Medicaid benefits in New York and were a resident of New York, but that wasn't your primary residence, because it would mean that you were living somewhere that you couldn't even get health
Also,
care.
what happens to somebody who's on diabetes, who lives in Florida 6 months, New York 6 months, but New York is their primary residence? What do they do when they go to Florida?
That's a very tough type of situation. I think what they probably do is they make some lifestyle choices about where they need to live. And I think that's the fundamental thing here, right? It's if you're elderly, if you're low income, if you're on Social Security, you're not kind of flying back and forth. You might see family for the holidays, but you're not going back and forth to just travel.
Well, if what you need are meds, right? You get a certain meds for a period of time, and you might have them mail the meds. People do that all the time.
Yeah, you might have medication mailed. It sort of depends, right? If it's
Have your
if they're
doctors in different
pills-
locations, people do that.
If they're pills, they might be different. But all that's being said is, if you have all of this, what I'm saying is that HPD just can't draw the exact opposite conclusion on the exact same type
Well,
of
from your
document.
perspective, for purposes of succession rights, what's the core characteristic of establishing primary residence?
So I think this court said it best in Yanaveth R, where it says this is on a totality of the circumstances. So you do want to look at this in the context of what succession is meant to do, which is to prevent people from being displaced. Having an apartment, having a home means that your family can come, they can come to you, they can take care of you,
And
they can
so
live with you.
here, applying totality of the circumstances, what was done that you would say supports that the way they acted was arbitrary?
Yeah, so I think if you really take totality of the circumstances seriously, you wouldn't be able to come up with a rule that says, we only look at documents from 1 year. And I just want to show you two ways that that's very sort of irrational. One way is, imagine if Ray had just passed away 1 month earlier, in February of 2019, or 2020. That would mean almost all the documents in this case are within the 1 year period. The HEAP benefits, the Medicaid benefits, the SNAP benefits, but that would mean that Kermit had less of a connection to New York. The fact that Ray had lived longer just kind of draws this arbitrary distinction where Kermit, in fact, now is subject to a 1 year period. The second way that I think it's arbitrary is that when you get Medicaid benefits or SNAP benefits in February of 2019, right before the 1 year period, it doesn't mean that you're only using them in February. I mean, like the fact that you get your SNAP benefits in Medicaid, presumably you need them the next month and the next month and the next month too, right? Like when you have Medicaid, it's not that you just need to go to the doctor once. It's that you have ongoing health issues.
So
And
the worst fact for him, I think, comes outside of the period as well, which is in October of 2018, somewhere like that, where he changes his bank account from one Florida address to another Florida address.
Yeah, I do think that's a really funny fact for him, and I think the opposing counsel on the other side cites some things from outside the record where there's 2 addresses in Florida, and one of them is his sister's address in Florida, and one of them was his old address in Florida. When you first, I mean, this happens with college, last case you talked about college students, but this happens with, for instance, like college students all the time. You move to a different address, you go off out of state for college, and you need to set somewhere as your mailing address. When Kermit came to New York in August of 2018, you don't know how long you're gonna be here for, right? You don't know how long Ray is going to last for. You don't know how long his care is going to go for. At that point, he had had a fall. And so when you have a very elderly person with both a fall and cancer complications, you actually have no idea what that care is going to look like. And so in that same exact month, just to give you an example, he also has things that link him to New York. He signs documents with Manhattan Plaza.
Wait, before you go there, the part about giving your address in 2018, doesn't that situation allow for a wide range of permissible conclusions, both in Kermit's favor and against him? I mean, where does it cross the line into arbitrariness?
Yeah, I mean, I think one way it crosses the line is if you credit those sort of documents, against Kermit, then I think the record needs to be opened up and HPD needs to say, I'm going to look at the documents that have Kermit's name on them, that also have his address as Manhattan Plaza from that month.
Well, if you're
August of
looking at them
2018.
relative to determining whether, if he comes in and begins from the proposition that he's living in the apartment during the relevant residency period, and you have something close in time, but you're using it to examine the claim that he's in there for the relevant residency period, is that really looking at what he did in the past, or just looking at the documents that you have available to you to inform the question of what's happening during the residency period?
Yeah, I guess this is maybe, if I'm understanding your question correctly.
I'm not sure I
Which is, I think if I'm understanding your question correctly, is like the fact that, for instance, if you signed a power of attorney in August of 2018 and you put a particular address down, it doesn't mean you need to stay at that address in order to exercise that power of attorney.
Correct, and it might not,
Presumably you-
and it doesn't necessarily mean that you're not living somewhere else in 2019, but it might be the only document, it's a small universe of documents, and this is what we have, and it's telling us something about what's going on in the relevant period.
Right. I mean, I won't quibble with you with the fact that documents that are closer in time to an event probably are generally more probative than documents that are far away from it. So kind of going to Judge Wilson's question about what about this, Wells Fargo change and sort of September,
My question
October.
there is a little bit different than timing. It's
Yeah.
really a couple things. I take your point that things outside of the one-year period may inform where somebody is during the one-year period, right? So would it be a permissible inference from that change of address that he has another address in Florida? Is that a permissible inference?
I think it would be a permissible inference to say he has somewhere else that he can sort of mail documents to.
Well,
And
but
I
it
think-
might be a residence. We don't know, right?
Yeah, it might be.
Or it might be,
it
it
could
might not be. It might be a friend's house.
Right. It could be a friend's house. It could be a sibling's house.
Yeah.
It could be some
Yep.
other residence
Or
that
it
he's
could be
able
a
to.
residence that he has, somewhere that he could live. We don't know. But that's an inference you could make from it.
That's an
And
inference.
is
And
it- hang on. Is it fair that you can also make an inference that it was relatively easy for him to change his mailing address on that account?
I think.
He changed it after he was here a month or so.
Yeah, I don't know if that's what HPD's decision
No,
rested on. but
I'm
even,
asking you something different.
Yeah, I think he probably could have
I mean, can
made
we
a
make
bunch
the
of
inference from the
different
fact that he
changes.
changed it when he arrived to take care of his sick brother, his brother's in extremis, he's, very busy with that, but he found the time to change his mailing address.
Yeah, there are certain things that I think I want to put on this sort of hierarchy of what are things that are necessary for you to change, right, when you move addresses. So if
Yeah,
you-
no, I'm just
if you
asking if
move
we
to-
can make an inference that that was something that was within his ability, given all the things that were going on.
Yeah,
I mean, he did it, so it's pretty hard
I think
to-
that somebody can change their address
And,
within
and
a
you can make
given
an
period
inference
of
from the
time.
fact that he did change it, that he knew how to do it, and in fact did it.
Yeah.
And then we have no evidence that he ever changed that again to a New York address, right?
No, we don't have evidence that he changed that to a New York address. What you do have is that in March 2020, before his brother died, that he tried to open a sort of Chase personal account with the sort of that sort of information.
Yeah.
Well,
And
let's
so
go back
he-
to the mailing that
Yeah.
you're being asked about by Chief Judge Wilson. Are you saying that, in your response, that it is the same amount of effort, considering the demands and the pressure, of course, and the emotional issues that Mr. Montilla is dealing with his brother, and we're not discounting that. Is it the same amount of effort to change one mailing address versus changing several accounts?
There's
Just to be
things-
clear how
yeah,
he
I-
changed this mail, to the extent it's in the record, I'm not asking for anything towards the record.
Yeah, I mean, that would not be a similar level of effort at all, right? And I would think the thing that you would most want to change are things that are, and this was kind of what I was trying to say, is the things that you most want to change are things that are fundamental to your ability to
What are those?
where you're going to eat, what kind of roof you're going to have over your head.
No.
and if so-
What
oh.
document, what proof of address stuff do you absolutely need to change when you're changing your address?
I mean, he needs to be on the Manhattan Plaza rolls as an occupant, which
Well,
means
he did a
to put his income.
certification, but that doesn't go to the, I'm talking about the type of documents that they list as probative on this question of permanent residency. And they have a list, and it's, utility bills, bank statements, tax returns. And I'm totally open to the idea that those might not be necessary things to change, but what is a necessary thing to change?
Yeah, I mean, again, I think how you're gonna eat, where you're gonna get healthcare, how you're gonna have a roof over your head are pretty fundamentally
So
necessary.
food benefits,
Where-
Medicaid benefits, Medicare benefits,
Yeah,
and
I mean,
what was the
and-
last thing you said?
And even where you have a
Where
roof
your
over your
roof
head, right?
is?
Like the
Yeah.
fact that you're gonna accrue rent obligations. And I see I'm out of time, but I just want to say one thing along the lines, because you didn't mention.
Oh, wait a minute, let's go back to this. What, with the change of address to a second Florida address, what was being sent there then? If
It
it's in the
was-
record,
It's just the Wells Fargo bank accounts that he has.
It's
So
just the
this is-
bank account.
It's $1,000 or $2,000 some dollars a month. It's a bank account where he has some money, right, presumably, and he changed the
where
address.
the Social Security money goes, the check?
That's not on the record.
I-
and we-
yeah, then don't
That-
tell me.
that- that-
I don't wanna
That's
answer
not on
that.
the record, at least where his Social Security map goes. But that is the address, right? It's not that he needs to go to that Wells Fargo branch location. We're kind of past
Is that
day
the
and age.
only thing?
I mean, that's the only thing that
In
he
the
changed
record?
during that time.
Yeah, okay.
Yeah, that's the only thing they changed that during that time. And then
To
the
the
only.
second Florida address?
Yes. Yeah. The only other thing that's even on the second Florida address is that Social Security letter, right? That's that February 2019 Social Security letter. But we know he was in New York at that time, and that's exactly when he was getting all of his other benefits in New York in that same exact month of February 2019. If I could just do 20 seconds on the utility bill, there isn't utility bills, but I think the HEAP letter kind of does exactly that sort of work, right?
Which letter?
The HEAP, the home energy letter,
HEAP
where he's getting home energy benefits in New York, does exactly that sort of work.
Thank you.
Thank you.
Hello, good afternoon. May it please the court, Chase Mechanic for the respondent, HPD. What Mr. Montilla is asking this court to do would be extraordinary. If this court were to reverse the First Department, then this
Well, let
would...
me ask you this, just as a theoretical premise. If an agency chooses to look at information pre the period, HPD looks at information pre the period that is only disfavorable to him, but there is also favorable information pre the period, and it
Yes.
chooses specifically to ignore that, would that mean that the determination against him is arbitrary and capricious?
I don't believe that's what the hearing
I
officer...
didn't ask that.
Right.
Let's just get to this first.
It could be. I'd have to look at what the written decision says, but it's entirely possible. However, that is not what the hearing
Okay.
officer did here. If you look at page 429 of the record, the hearing officer expressly considered information that was favorable to Mr. Montilla, from before the co-residency period. Specifically, the hearing officer considered the Chase Bank statements from 2018, 2019, and 2020. This was explicitly noted in the decision, and although she took notice of this evidence, what she said was she didn't consider it sufficient, reliable, and credible evidence corroborating his claim of primary residence.
Well, how is that decision genuinely reasonable and rational in the specific context presented as required by Murphy?
Well, I'd love to extol all of the ways that the petitioner in Murphy presented copious amounts of evidence that are quite different from here. In Murphy, I mean, the first thing to note in Murphy is that, unlike in this case, all of the evidence in Murphy pointed one way. So it was directionally uniform. It all corroborated the claim of primary residence. And the court can look at this.
But with respect to the specific context, did the hearing officer have to look at the evidence based on this person, their circumstances and situation? Or you're suggesting that all individuals are treated the same, regardless of the context of how they're living, circumstances they're facing?
All individuals are, the law applies the same to all individuals, but of course it is a totality and circumstances test.
Right. So how is it supported here that all of the totality of the circumstances in the context of this individual supports that this was not an arbitrary decision on the part of the hearing officer?
Because in the context of this individual, we know from pages 292 to 296 of the record that Mr. Mantilla, for example, had an alternative source of funds, the Wells Fargo account. We know from looking at those statements that he received online banking statements. It's inferable, therefore, that the statements would have been accessible to him. The fact that he did not produce full and complete copies of those statements, which were associated with the Florida account, and indeed during the period of time when he claimed he was living with his brother.
And the Social Security benefits that he received? Isn't there evidence as to what his income was, regardless of a tax return and the things that you say he did not?
Well, there is evidence of what his income was. The issue, though, is his primary residence.
Correct. But regardless of where, you can have a bank account and have a bank card in a different state, but doesn't mean you don't live somewhere else.
Well, that is
You can have access to those funds.
Well, that's an inference that the hearing officer had to make. I mean, when we are in Article 78, we are sitting in review of factual determinations that have already...
And what about the information with respect to SNAP benefits and other things that he was receiving directly from New York?
There are 10 months out of the 12-month co-residency period where his receipt of SNAP benefits and other public assistance benefits are undocumented. 2 months into the co-residency period, we have a couple of letters from SNAP suggesting that he remained enrolled. However, where are the SNAP recertifications? Where are the EBT card reports from that co-residency period?
So again, it was proper to focus on the absence of certain documents, even though you could, in the totality, come together with the information that you want, that you required.
Well, I don't know if the hearing officer could have drawn a separate conclusion. I think the
But you
question...
keep focusing on what was not provided.
Yes.
So
Because-
what about what was provided?
Well, what was provided was conflicting in several respects, and I'll get to that. The first thing I want to say, though, is that we cited cases from the First Department, even where all of the evidence that is provided corroborates the claim of primary residence. If the quantum of evidence is insufficient, then courts have still held that it is rational for HPD to determine that they haven't satisfied their burden of proving primary residence.
Counsel, I'd like to change the subject, and you can go back, but I just want to get this question in before time runs out. It seems to me, under my understanding of the requirements that were explained to him in the succession appeal letter that he received, that there's an independent requirement that he submit a tax return or a statement explaining why he doesn't have to submit a tax return, which my view of the record is that wasn't done at all. And I think the letter, the explanatory letter, says that's an independent grounds for denial of succession, but the AHO doesn't get into that at all. really in the decision. What are we to make of that? What can we do with that? You know, how do we work with that absence?
Yeah, I think what you do is you apply the governing law implicated by the decision to the facts found by the hearing officer. So the facts found by the hearing officer were that the only objective evidence that Mr. Mantilla submitted, other than the income statements, which are alone insufficient,
Right.
the only objective evidence were the 2 SNAP letters that I mentioned.
So it's all about primary residence. There's no grounds here for finding that the application should have been denied based on the failure to submit a tax return.
That's not what I'm saying. There is a ground for that.
How do you do that?
I mean, so first of all, from the inception of this proceeding, the parties have litigated this case before it came to this court on the understanding that that the tax return issue was embedded in the decision and would be a basis.
I know, you argue it, but, you know, it's not in the decision.
So what the decision says was, by implication, because the only evidence was the 2 SNAP letters, that means that the tax returns contemplated by 302 and 4 were not submitted. And I mean, this is footnote 4 of Brookdale. It is close enough to the agency's reasoning that I think you can uphold it. And I don't think it would be fair for parties to litigate the matter at 2 appellate levels on the understanding that the agency's decision was irrational because it relied on taxes, and then when the case finally gets to this court, argue that actually it was irrational, or actually it did not rely on it in the first place. That is not how these proceedings are litigated. If I may return just momentarily to the financial records and the SNAP records, with regard to the North Miami address, at page 273 of the record, that is the Social Security letter from February of 2019 reflecting the Florida address. That indicates that the North Miami address, the address which my adversary claims for the first time in their reply brief, was actually the sister's address. Of course, that's nowhere in the record. That address is associated with Mr. Mantilla's file with the Social Security Administration. So even if this explanation that it was his sister's mailing address had been proffered to the hearing officer, which it was not, it still would have been rational for the hearing officer to not necessarily credit that explanation because it was also the address tied to his file with the Social Security Administration.
Well, or to credit it, and to credit that his principal residence was his sister.
Right,
Sure,
I mean,
right.
it's 6 in one hand, half dozen. Yeah, I agree with that. And so just returning to the SNAP for a moment, as I was beginning to explain, we have an EBT card report in the record. There's no question that he was physically in New York after his brother suffered an acute medical event. He applied for public assistance. There's no waiting period to do that. He received public assistance, and there's an EBT card report for December 20.
Yeah, I was going to say, would you agree that it's very unlikely that he went back to Florida at any point during this period of time?
No, I wouldn't say that, or at least I have no way to make heads or tails of it, and I don't think the hearing officer did either, because most of the co-residency period is not accounted for other than through these income recertifications, which could have indicated physical presence but not necessarily residency.
Are you putting in question the severity of his brother's illness?
No.
That
I'm
he
not-
was the primary caretaker?
Well, even if you assume that
Based on the record, I'm not
I
asking
mean,
for anything else.
the fact is, he did not submit evidence as to the duration and persistence of his caretaking responsibilities. So if this court is to hold that the hearing officer acted arbitrarily because she didn't account for those caretaking responsibilities, I believe that holding would be divorced from the evidentiary record.
And did he provide information as to his limited resources?
Yes, he did.
So suggesting that he's flying back and forth from Florida to New York? With what?
Well, in the Chase Bank account, which he argues he had access to, there were other funds going in. I mean, again, this goes into the area of
Funds that did not cause him to be excluded from SNAP benefits or other public assistance?
well, again, the SNAP benefits are not.
You're saying he wasn't poverty-ridden?
No, I'm not. I'm not. He was of limited means. The SNAP benefits are only accounted for the first 2 months of the co-residency period. We don't have any
So
information.
let's say he goes back, what? How many times would he have to go back to Florida where you would say, well, that just, you can't have a primary residence in New York? We're not talking about going back every weekend. I don't mean
Right,
that.
we're not. It's not
Once?
about,
Twice?
it's not about the frequency, potentially, depending also on the duration of time that he spends there. One of the factors that the hearing officer looks at is the number of days, whether it's 183 days above or below that they're spending at their claims
But
primary
is there
residence.
direct evidence that he went back to Florida?
There's no direct
No.
evidence.
So
But this is
would
a,
it be speculative to assume so, given,
You don't have to-
given the condition of his brother and why he came?
the
to
hearing
New York?
officer wouldn't have to assume so to deny this application. Mr. Mantilla is the party with the burden. What Mr. Mantilla has to do is exclude the alternative possibilities to show to the satisfaction of the hearing officer.
That's what I'm
that-
saying, if he's showing his financial status, the condition of his brother, why he's here.
But those are factual inferences that are reserved to the hearing officer.
Yes,
and
but they have to be reasonable.
And they have to be reasonable, but the hearing officer reasonably weighed that against other countervailing evidence, including the, as far as I can tell, the unsatisfactorily explained financial records showing Florida and a change of Florida address, the Social Security account tied to Florida, and the absence of public assistance documentation that he hadn't produced for the period prior to the co-residency period, but for reasons that are yet unexplained, he did not produce for the latter 10 months of the co-residency period. And just as courts may draw adverse inferences when a party has information likely to be in their possession that they do not disclose, administrative agencies may do as well. And that is a particularly important doctrine when you have a non-adversarial proceeding such as this one, where the applicant is in control of the administrative record. Well, I see my light is not on. Happy to answer any other questions, but I'll just make another point. If this court were to reverse the First Department on this record, then this would be the first published appellate decision of which we're aware, and my adversary has not cited any contrary cases, in which there was conflicting evidence as to the applicant's address, and in which the appellate court nevertheless held, as a matter of law, that the hearing officer was required to resolve those inconsistencies in the applicant's favor and find that they were entitled to succession rights. And so I think that the implications of this case would reverberate outside of the context of the circumstances of this one case. They would reverberate outside of the circumstances of Mitchell-Lama succession principles. I think that future litigants and courts would look to this case, if this court were to reverse, in order to challenge the reasoned judgment of administrative agencies when there's a mixed record, and I don't think that would be appropriate for the development of administrative law principles. Does the court have any other questions?
No, thank you.
Thank you.
Just want to make 3 really quick points, just picking up on the very last point. We're not asking this court to make some broad pronouncement about what to do in cases where there's conflicting evidence. All we're saying is, yes, you can make a decision on conflicting evidence, but then you need to treat the same type of evidence the same way on each side. The second thing is, Your Honors had a brief colloquy about the absence of evidence and what that means. And so I want to point you on page 429, there's a very small paragraph in the second full paragraph, and the hearing officer says, well, you know, the only documents are what reflect Mr. Mantilla being in the apartment in New York during the 1-year period. And so, sure, maybe you can weigh the absence of evidence, but then you also have to weigh the complete absence of evidence of Florida from the 1-year period. There are 0 documents that say Florida within the 1-year period. So if you're going to draw that sort of adverse inference against Mr. Mantilla, then you have to do the same thing with respect to Florida documents and say, there's nothing linking him to Florida within the 1-year period. And so the hearing officer can weigh conflicting
Well,
evidence.
I wouldn't have expected him to put any in.
I don't think that's exactly correct, Your Honor. I mean, I think individuals, especially individuals who with sort of limited means, I think they're trying to their best to assemble whatever they have. That's why there are some documents that say Florida on it. There's some documents that say New York on it. He's not trying to hide it. There's some accusation that he was trying to hide the Wells Fargo statements.
But counsel, even if that's true, even if, you know, some litigants just put in everything they can get their hands on, the relevant inquiry for the hearing officer is the residency in New York. And, and in that regard, there is conflicting evidence. Some of it points to Florida, some of it points to New York. Why shouldn't they be allowed to make their own determination about that?
I think you can make your own determination. I think that's why this case doesn't set a precedent this way. And I just want to draw out this distinction between Murphy, because my friend on the other side does mention Murphy. In Murphy, Supreme held and declared that this individual was entitled succession rights based on overwhelming evidence, because there was only one possible reading at all to read the evidence.
It all went one way for
It all
a
went one
really
way.
long period of time.
What we're not saying is that this individual has to get succession rights. What we're saying is you should at least remand this, have this remanded down to HPD for them to have a decision based on all the facts before them, based on information that predates the record and postdates the record, based on sort of making equal inferences based on the same exact type of documents, and resolve those
If you would
conflicts.
just summarize it one more time, what is it that they didn't consider that they should have?
They didn't consider information that predated the period, and they
Yeah, well,
did
what,
so.
specifically, what are you talking
The
about?
SNAP letters, that predated the period, the HEAP letters, the home energy letters that predated the period, the Medicaid letters that predated the period, a whole 2 batches of income recertifications that predated the period, exactly had February 2019, which accrued rent obligations within the period. So the fact that a document is dated within the period doesn't, or dated just outside the period, doesn't mean that you can sort of ignore it as sort of evidence as probative within the period. So that's all that we're saying, is not that you have to go as far as Murphy. I think my friend on the other side would be correct if this court went as far as Murphy and just said, on any case that's conflicting evidence, the Court of Appeals can come in and say, I actually think this is a little bit different, and so I'm going to revise the judgment of the city or any other administrative agency. I think this is different because all you have to say is, if there's conflicting evidence, the hearing officer just needs to apply the same type of reasoning to those sets of conflicting evidence. So they can make credibility determinations. They can say, the older the documents are, the less weight they have. Those are completely okay in terms of the type of reasoning they use. Thank you, Your Honors.
Thank you. Next case on the calendar is a matter of Coalition for Fairness versus City of New York.
Good afternoon, Your Honors. May it please the Court, John Shepwong on behalf of the appellant. I'd like to reserve 3 minutes for rebuttal, if I may. Thank you. So I'd like to begin with the predicate question in this case, and that's whether the government action here can be thought of as a taking. If it can't, that ends the analysis, and the First Department completely ignored that aspect of this. And there's 2 reasons it's not a taking. Number 1, the action challenged concerns a pre-existing undisputed restriction, and refusing to allow petitioners to remove it and to add to their bundle of rights with regarding to their property does not take anything from them.
But counsel, they're offering a benefit here, right? So if someone came in and asked for this benefit, asked for a variance on a zoning, and you put a condition on that, why is that different under Sheets than the government doing it this way?
Well, here's the difference, Your Honor. I think that what's important to remember is that there is this restriction that runs with the property. It's a specific use restriction.
And if you lift that restriction, which you can do right now, the property increases dramatically in value. I understand that, but that underlies all of these cases. I mean, if they weren't giving a value for the condition to be posed, then why would anyone do it? So you're always increasing the value of your property by getting some benefit from the government. Here, changing the status from artist restricted to residential, let's call it.
Respectfully, I disagree, Your Honor. I think that all of the cases that have preceded this one have all concerned, none of them have concerned this type of restriction that is running with the property, that is specific to the property. All of them have concerned overarching permitting schemes where the government has a role in granting or denying permission to develop the property.
Could you grant or deny a zoning variance? If something's zoned a certain way, can you grant or deny a zoning variance?
I think a zoning variance would be in a similar vein of the permitting regimes of the Coons, Nolan, and Dolan.
It seems like this is a Sheets-type zoning variance law.
I disagree, Your Honor, because what we have is a restriction, a specific restriction that
So what is the
attaches to the
difference
property
between
itself.
what's the difference between a rezoning and a zoning variance qualitatively?
Qualitatively, I think what's important to remember here is that, in the permitting realm, in the zoning variance realm, you have the government able to make a decision as to whether or not there's going to be, a certain kind of development. But what we have here is an existing restriction. The government's not doing anything to impose that restriction. So when in the variance world and in the permitting world, the government, the action that is being taken actually diminishes the property, the
What I
rights in the
think I
property.
hear you saying is that in a rezoning, it's available to everyone who holds that kind of property interest, the restricted property interest. And in a variance, it's a particular individual who's seeking the variance. Is that right?
I think that, no, I think that the way that I would describe it is, so we have this permitting regime. We have a variance regime where the government can take an action, can say, you can have this permit, you cannot have this permit. You can have this variance, you cannot have this variance. And what that does is it imposes an actual restriction on the property when the government says no. When the government says, no, you can't have this, or if there's a condition that's imposed on it, the government has then
So you could say you
burdened
can
the
have this
property.
permit if you pay us $20,000, let's say, and anyone who pays it can have this permit. How is that different than this?
And anyone who pays it can have this
Yeah.
permit? In the sense, well, it depends on
And then you're
what this
getting a
underlying.
benefit, right? You're granting a benefit by statute to everyone. There's no individual decision there. Isn't that Sheets?
It depends on so Sheets didn't address any of this at all.
Well, Sheets didn't address whether it's a taking, but Sheets addressed whether you can do this by legislation, right?
Sheets addressed whether you can do it by legislation, but I submit that that's a different question from what I'm discussing here, which is whether the government action can be thought of as a taking in the predicate sense. So that is,
But you seem to be saying one of the reasons it cannot be is because they did it this way, rather than as an individual zoning variance. But I think Sheets addresses that, doesn't it?
no, Your Honor. So I think that the difference is in terms of what the underlying restriction on the property is. So I think that the question of whether it's being imposed as a legislative rule or not, and I think that that is an important factor in the rough proportionality analysis. I think that is different.
Why is that true under Sheets? I thought Sheets suggests that the fact that it's being imposed broadly does not take it outside the universe of what constitutes taking.
It doesn't take it outside of the universe that constitutes a taking, but it is a factor that can and should be considered. And the concurrence
Under
in
which
Sheets.
of the Supreme Court's cases would you say that's true?
So in Sheets, and in Dolan, I would reference the court to Dolan, which referenced the legislative aspect of whether this was being imposed as an individual adjudication or a legislative scheme. So the difference here is that we're not asking for Nolan and Dolan not to apply because it's being because this was imposed as a legislative act.
That'd be hard to argue after Sheets, I would.
Of course, but I think that what we need to keep in mind is the concurrence in Sheets, both of them, Justice Kavanaugh's concurrence as well as Justice Sotomayor's concurrence, which focused on how narrow that decision actually was.
Well, perhaps one could read those concurrences as noting that those questions remain open, but I guess I'm still not quite tracking what the crux is as to your argument why this is not a taking. Maybe I'm just not tracking.
So let's set aside, I think, the legislative aspect. I think that
Yes.
what our argument on that is focused on the application of Nolan and Dolan and not the predicate question as to whether there's a taking involved here that would trigger Nolan and Dolan. So I think that the difference here is the underlying restriction, what the government action is trying to do. So I think that Justice Barrett in Sheets, for example,
When you say the government action, do you mean the initial zoning restriction, or do you mean the opportunity now to procure different use through payment of this fee? Which of the two?
I think the opportunity now to, so what is the government doing when it says you have to pay a fee or you have to do this other thing to get a permit? So I think that that is what is the impact on the property from the government decision there, I think is the rub here. And I think that the difference between this case and Nolan, Dolan, Sheets, and Kuntz is that here we have a specific use restriction, undisputed, that pre-existed
Say
this.
it's the same situation here. They're single-family homes, though, same restriction. And as a condition of this legislation, as I sent to you, you say, you can do this, you can change the status from residential, artist to pure residential, but you have to give us an easement. Is that a taking?
Well, I think that there are two, that goes to the two reasons that I think that there's
No,
not a
but let's
taking
stick
here.
with
But
your
the
first reason.
the
That's
first
the
one-
same benefit you're giving under the same legislation, but instead of saying you pay my arts fee, you say, I want an easement. But under your first reason, as I understand it, that would be okay.
I think that that would be okay under this analysis because what is happening with the restriction is that it's not changing based on what the
So
government is
you're
doing.
if you
saying
want to
that-
change it, I get an easement. The government gets an easement to allow you to change it from artist residential to residential.
That would be an extension of this, of the first prong of
That,
our
in your
argument.
view, just so I'm clear, would not be a taking under Nolan, Dolan, Kuntz.
It would not be a taking because of the particular restriction that's being applied here.
I'm not following that. If there's an easement that is required instead of a payment, why is it not a taking under the Supreme Court's case law?
So there's two issues here, I think, Your Honor. So that there's the monetary obligation, which,
Right, but
That's
hypothetically, I'm saying if it's an easement that is required, so let's assume that what the city says is, you can convert, but you have to reserve your first floor for art gallery space, let's say, okay? I hear you saying, I think, that that's nonetheless not a taking, even though it would be an easement, but I'm not clear why.
it's because of what the government action is applying to, how the government action is applying to the property. So, Justice Barrett in Sheets described the interaction between the police action and the takings realm as in-laws and not
I
soulmates.
appreciate that there's not an easement required here, and maybe that's relevant to our determination whether there's an exaction, but I'm still not following, where under the more, Nolan, Dolan, Kuntz, Sheets, is there a clear suggestion that an easement is not a taking? It may be permissible if it satisfies the Nolan, Dolan scrutiny, but how do we get to the point that it's not a taking in any event?
Well, I think that what we have to remember is that Nolan, Dolan, and Kuntz and Sheets never addressed this particular scenario.
How is it
where
not a
there's-
taking here on this particular regime?
Because of the underlying restriction, Your Honor, because of the underlying restriction that already exists, that it predates anything having to do with this case, and because the government
What if
action
it was a
doesn't actually
permit? I'm
change
sorry,
anything with
What if
regard
it
to
was a
that.
permit, and you can't build two-story houses, and you need a permit to build above a one-story, and we pass a law that says anyone who pays us, anyone who gives us an easement can build two-story house. You get a permit. That would be okay or not okay? Because there's a pre-existing restriction on your home, you can't build a two-story house.
If we're assuming there's a pre-existing restriction, then it would be more like the scenario that we have. But what we have in Kuntz and all of the others is there is no pre-existing restriction.
But let's
You
say my
have-
scenario, there is. You need a building permit to build above one floor. And instead of making you come in and get a building permit, we pass a law that says anyone who gives us an easement through their property can build two stories. Violate, taking or not taking?
So I think that's, so we're assuming that there is some kind of restriction on this property that's specific to that property. So
Whole development zoned, you cannot go above one story. You have to get a building permit to go above one floor. Pass a law that says, hey, that's our rule, but if you give us an easement through your property, then you can build two stories.
Well, I think what's relevant as to whether that restriction is, whether it's a broad-based, rule in terms of whether there's a permit that has to be sought, or whether it's a specific restriction on the ownership rights of the
And how would
party.
that hypothetical be dissimilar from what's happening here? Because it does sound awfully close.
So I think that the difference is whether there is a specific restriction on the property owner's rights in this case. In this case, there is.
On the property owner's what?
On the property owner's rights. In this case, there is.
Well, I mean,
There
in
is
in this
no-
hypothetical, no one can build above one story.
And there, but in the, I think the hypothetical, as I understand it, is that there is a rule, a broad-based rule that requires the government to weigh in on whether they can build above one story or not. That's not a specific restriction that's attaching to the property itself. It's not
What
in
does
this
weigh in mean?
case-
It's a zoning restriction. This area is zoned for one-story houses or buildings only. But if you want two stories, you just have to give us an easement and we'll give it to you.
I think the difference is that whether it attaches to the specific property or not. So that sounds like, to me, like a broad-based rule, and what we have here is a stick in the bundle of rights that the property owners never had, Your Honors. So I think that,
Your red light went on. Do you want to just take a moment to, assuming that it is taking an exaction, whether or not it would satisfy Dolan, Nolan standard?
Sure, and I do want to point out that there is an additional
do have your red
reason
light
that
on,
there is
so-
not a taking, which I can get to on rebuttal, but in terms of the essential nexus and the rough proportionality, I think that what's important to remember here is that the nexus relationship that the petitioners are advocating for, that's not represented in anywhere in the case law. What we need, and according to this court's case law in Consumers Union and Twin Lakes, and as it interprets Nolan and Dolan, we need a consistent relationship between the stated purpose of the restriction and the condition. And the stated purpose that's from Sheets. This is not a strict standard. Dolan teaches us that it can be a theoretical standard as long as there's an articulable connection between the restriction and the condition. So what we have here is a denying conversion preserves an artistic amenity that has supported the creation of art in the city, and that's exactly what
Do you
the
know
Arts
how
Fund
many
fee
artists,
does.
I think there are 1,636 units, and I saw something here that 1,600 of them are occupied by non-artists.
That is an estimate that the legislators in this case put forward. I don't know whether that's an accurate estimate or not.
Is there anything else in the record to suggest it isn't?
Well, what's important to remember, I think, is that there's no dispute that there are certified artists in these
So if there are
units.
36 out of 1,636 units, what are you preserving?
So I think that what's important to remember here is that, obviously there have been a lot of changes with regard to the use in Soho and NoHo. And I think that, the amnesty has had a role in this as well in terms of suppressing the number of certified artists that have appeared in these, that occupy these spaces. But I think that, there's an assumption here by the petitioners that there is no certified artist market, that there cannot be another certified artist market once these amnesties have elapsed. And I think that, that's just not borne out in the record. And I would point out that there is a presumption of constitutionality here, that it is the petitioner's burden to demonstrate that these are, that there is no market for them, that this is totally illusory, I think.
It really seems to me from reading the record that what the fee is trying to do is to do what this restriction hasn't done. It's failed to do. And that I don't see as a nexus, because by lifting this, you're essentially accepting reality of what's on the ground here, but you wanted it to do something different originally when it was done in 1971, and over time it's become evident that it isn't doing that. So the loft law came in, and a lot of them were transferred into lofts, some weren't. Now most, if not nearly all, are occupied by non-artists. So facing reality, you're offering this change, but it isn't a harm from the change, it's a harm from the failure of the project.
I disagree, Your Honor, because I think that assumes that this never had a role in the way that Soho and NoHo has developed. I think that the record shows that there have been thousands of certified artists over the years. There are still certified artists today being certified every year through this process.
Last year?
Granted, there are not that many. A lot of that has to do with the skyrocketing property values in Soho and NoHo, as well as the amnesties play
And
a
that's
role.
under current market conditions. And as I understood it, the increase, the $100 per square foot, was based, I think, although this is unclear in the record, although I think you say it in your brief, on some idea that artists would now be priced out by the increase. in property value. But if you're saying they were already priced out, what, again, is the harm you're addressing?
The point is that there are fewer artists that are qualifying for this, certainly. I think that's undisputable. But that doesn't mean that there are no artists. That there are still, to Your Honor's point, this year, I think there have been roughly 23 in the past 5 years that have been certified. There have been, there have been less than 10 over the preceding years per year. But that trend doesn't mean that, again, that there isn't a certified artist market or that the certified artist market cannot rebound with additional enforcement of this rule. So I think that assumption that this has no role here just ignores the fact that the market study that Your Honor cites definitely shows that there is an ongoing impact with regard to this, with this use restriction, this artist restriction. So,
Where is that in the record, that this increase will price out artists? I know you say in your brief, I think, but is there anywhere in the record support for that?
I don't think we're saying that it will price out all artists. I think that what we're saying is that these two things are flip sides of the same coin. And I think that's a common sense assessment, that the increase in value for either to purchase or rent in one of these units has a direct impact. It's the flip side of the coin for the impact on artists who would want to occupy the space, to use the space for the making of art. So I think that is, evident from the record. And I would point out that the study is not challenged in any way by the petitioners in this case. So I think that is a fair inference to be drawn, because that's just the way that the housing and real estate market works, Your Honor.
Thank you.
Thank you.
Good afternoon, and may it please the court. Chris Kieser for the respondents. The First Department correctly held in this case that the Arts Fund fee could not satisfy either Nolan's nexus or Dolan's rough proportionality requirement. As far as nexus, the record is clear that the Arts Fund is not intended to replace the loss of space.
Can I ask you, suppose there was a $250 fee that was charged for a permit. Would you argue that that was a taking?
Your Honor, the permit application fees typically are not, if they are related to administrative costs, for instance, like something like user fees.
But is related to a nexus question, or is that about applying Nolan-Dolan scrutiny, or is that about deciding whether it's an exaction? I'm not familiar with cases where courts have said a routine permitting fee is an exaction and then applied the Nolan-Dolan scrutiny. So how do we distinguish those fees if they're permissible, which I take it you think they are?
First of all, Your Honor, this is not a routine permit
I understand. I'm asking a hypothetical.
But second of all, Kuntz here actually controls the predicate taking analysis. As in Kuntz, the court specifically held that the government's demand for property from a land use permit.
So your view is that any routine permitting fee, let's assume it's reasonable, is an exaction subject to Nolan-Dolan scrutiny?
That's not quite true, Your Honor, because I think that some of them could be considered user fees, such as like sort of a court filing fee, if they are
Okay, so let's suppose I want to, build something and I need a permit to do it under some longstanding law, and the municipality imposes a fee of $250. I'm trying to understand whether your view is that is an exaction, but it's permissible under Nolan-Dolan scrutiny, or it's not an exaction at all?
I think that a normal permitting fee that's designed to cover administrative costs probably would not cover, or would not implicate Nolan-Dolan.
So let's say it goes 100% above the administrative costs.
I think once you...
Is it an exaction?
Your Honor, once you get beyond the goal of covering administrative costs, then you're looking at Kuntz, which talks about how monetary exactions are, that controls the predicate takings question.
But what makes it an exaction, I guess, is the question we're all struggling with. Is it just the fact that it's over and above what a nominal administrative fee would be?
I think that administrative fees, Your Honor, would be justified based on the administrative costs, like a typical user fee.
That's easy to understand, but what demarcates the transition between a user fee and an exaction?
Well, here, Your Honor, the, the city is not saying that, that the arts fund fee has anything to do with the process of conversion at all. In fact, conversion, really, if you look at the record, is...
But it's a fee, and governments charge fees for things all the time. And they can, they permit, we don't generally hold that governments are restricted from creating fees for certain activities.
That's true, Your Honor, but this is a fee that on average is about $250,000.
So if the concern is that proportionality question, right? Why don't we think about this as Justice Kennedy suggested in Eastern Enterprises, where my recollection is he said something that may be, disproportionate or extreme in terms of the amount is appropriately analyzed that way and not as a taking.
Your Honor, I actually think that Kuntz is an application of Justice
But
Kennedy's...
in Kuntz, there is, I thought, correct me if I'm wrong, there's an alternative. It's either give me your easement or give me some money. Am I wrong about that?
Yes, you are wrong about that, Your Honor. The Florida courts in Kuntz actually were very clear about the fact that it was a monetary exaction and that it was not an in lieu fee.
I thought I might be misremembering the facts, but I thought that when it initially, during the initial interactions between the local government and the landowner, there was some suggestion that perhaps a larger easement would be appropriate or a monetary payment. Am I wrong about that?
There were some negotiations between Mr. Kuntz and the Water District about maybe the possibility of him being able to develop a smaller portion of his land in exchange for some other...
So your view is that Kuntz stands for the proposition that money alone, no suggestion of an easement, is a taking? I read, I guess, particularly the concurrences in Sheets as suggesting that's an open question before the U.S. Supreme Court.
Kuntz, in my view, decided that question. That's the reason that the court granted cert in Kuntz, because the Florida Supreme Court had held that monetary exactions did not trigger Nolan-Dolan scrutiny. The court granted cert on the question of...
So what do you make of the concurrences in Sheets then? What are they getting at, if not to suggest that that's an open question?
I think, Justice Kavanaugh's concurrence, as far as the class of properties question, I think that goes to the rough proportionality inquiry of to what extent do you have to defer to a legislative fee schedule, but the predicate question of whether Nolan-Dolan applies to...
Well, I think just Justice Sotomayor's concurrence, I think, says that the question presented here doesn't include the antecedent question whether the traffic impact fee would be a compensable taking if imposed outside the permitting context and could therefore trigger Nolan-Dolan scrutiny. Maybe you read that differently, but I read that as suggesting that question is open.
Perhaps that was her view. I think that Kuntz is clear that the reason that the case was even taken in the first place in the Supreme Court was to answer that question.
It's hard to know why the court takes a case, I assume. I'm not sure that can be dispositive of the scope of its
That was the
ruling.
question presented, Your Honor, because the Florida Supreme Court had held specifically that monetary exactions are not subject to Nolan-Dolan. And then when you read the majority opinion in Kuntz, it's clear that it's an application of Justice Kennedy's concurrence from Eastern Enterprises, and the thing that makes the monetary obligation a taking in the exactions context is that it is connected to a discrete property interest. It burdens that property interest.
Do you think that you could have brought a due process claim challenging the amount of the fee as disproportionate to, any reasonable metric?
I suppose that's possible. The standards for due process are different, and that's not how this case proceeded. But I suppose that that's possible. But I think Kuntz applies that Eastern Enterprises standard from Justice Kennedy's concurrence, which is controlling, and that's the connection.
So let me ask you then, if it's about the burden on the property interest, what is the existing property interest that's burdened by this fee?
Well, first, I would point out that in Nolan, Dolan, Kuntz, and Sheets, and in fact in any other unconstitutional conditions case outside of the land use context, The government always has the discretion. It's assumed that the government has the discretion to deny the permit. And so whenever a permit is granted, it's an expansion of your rights. For instance, the property owner.
But there's no permit at issue in this case, is there?
Well, the JLWQA residents need a permit to convert, according to the city, they need a permit to convert their use from JLWQA artist housing into general residential.
Right, but this is not, I mean, I guess, maybe this is just a question of logic, but they're not telling anyone they have to do that. They're just saying this is how you convert the status of your property.
It doesn't diminish the value. Or do you think it diminishes the value?
No, I think that every permit, and I think Kuntz addresses this at page 605 of the opinion, every permit is extremely valuable to the permit applicant, and that's why the permit applicant would want the permit in the first place. The thing that creates the leverage for the government to actually impose an unconstitutional condition is that the permit is so valuable that an applicant might be willing to pay something far beyond nexus and proportionality to receive it, and that's why Nolan and Dolan exists as a safeguard.
But I'm still struggling with it because you don't have to change the status of your property. You can continue to keep the property with the existing restrictions on it and thereby avoid the fee. No one has diminished the value of your property.
For one, Your Honor, that's true until you want to transfer or bequeath it. So some of these people, when they die, and they want to bequeath it to someone, that's going to happen.
But that would be the same group of people, whoever you could bequeath it or transfer it to would be the same population that you could have before this entire regime was put in place.
Because of the lack of certified artists, the chances of being able to transfer the property to a certified artist are fairly minimal at this point. But I would just point out also.
That's a statement about the economic conditions present in the city, but I don't quite understand how that informs this question.
I think when it comes down to it, it really doesn't matter whether it's mandatory or voluntary, because of course the permit, the property owner in Nolan didn't have to build a single-family home.
But if you took the property in the first place with a restriction and you don't have to switch it, why is it different?
Every single one of these cases, Your Honor, involves a permit application which could be denied, and that's the underlying fact about these cases.
Well, but the difference here is that the individuals who would seek this permit, don't want to pay this fee, had an interest that did not include the tremendous increase in fair market value that they are looking for. That's a difference, right?
I don't think it really is, because in any of these land use cases, the permit is required to do whatever the applicant wants to do. So when the applicant in Nolan wants to build his single-family home, he had to apply for that permit, or else he was not going to be able to do it. And the Supreme Court assumed that the Coastal Commission.
They're not changing it from a single-family home to a two-family home. It's changing the essence of the actual interest. The interest is a very limited interest.
I think that any of these permits, and if you go even to the welfare cases and other unconstitutional conditions cases, the same thing is true, that the interest is not something that one had before, and the permit could be denied.
They got a fee simple, I want to change it to a two-family house. They don't have that. They have a very restricted residence.
And I would also point out, as a matter of fact, that
and they can still profit off of it.
the city.
They just still have to maintain that restriction on it. What they are looking for is to remove a restriction, and so they say, all right, we finally decided we're going to allow that, we're going to lift the restriction, but we need you to pay this fee to do that.
And this actually kind of leads into nexus and proportionality, because the fee that they're asking the JLWQA residents to pay doesn't have any relationship to what.
Can we go back to Kuntz for just a minute before you turn to that? So Kuntz says that the fulcrum of the case is the direct link between the government's demand and a specific parcel of real property, right? And also says explicitly that it is beyond dispute that taxes and user fees are not taken. So what I'm trying to understand is, why should we not think about what we have here as a user fee, because it's not tied to a specific parcel of property, right? My understanding is it's true across the district. And if the concern is that it is completely out of whack with anything reasonable, and that may be a colorable argument, that can properly be vindicated as a due process concern.
Your Honor, for each one of these properties, it is tied to a specific property. For each one of these 1,636, they each need a permit.
Not in the way I don't think Kuntz is. That's what I am struggling with. It seems to me that in Kuntz we have, maybe I'm missing something, but in Kuntz I thought we have a specific parcel of property, and initially the municipality, I forget what the exact entity is, you probably remember, but the municipality says, okay, maybe you could give us an easement, maybe you could give us a lot of money, but it's clearly focused on that specific strip. And I thought that what we have here, by comparison, is a broad requirement that a fee be paid that is high for a conversion across all properties that qualify in the district.
Your Honor, the question of whether it applies to one or all properties, that's the ad hoc administrative versus legislative exactions question that Sheets answered. So it doesn't, but in each individual one.
Sheets leaves open, as I think you just said a few minutes ago, the question of what kind of scrutiny might apply and how to treat, how to treat.
That's true, but in this case, we don't need to get to that because as the record demonstrates on its own, there's actually really no impact of these conversions that can be attributed to the JLWQA residents themselves. And in fact, the city wants the JLWQA designation to go away. That was the whole purpose of the rezoning. The only reason to keep it the way it is so that they could require the JLWQA residents to then contribute to the Arts Fund fee in exchange for a conversion. But the long-term purpose of the rezoning is to increase residential use in Soho and NoHo, and getting rid of the restriction furthers that goal. So the only reason to keep it in place in the first place would be to use it as a means to transfer the cost of this arts fund to pay into public art from the public as a whole to these 1,636 residents. And that's why the arts fund fee violates.
Well, there is residential use. I mean, we're not talking about changing a commercial edifice to a residential edifice. It is residential use.
Well, I'd also note that to convert to commercial, there's no fee. And so that's another aspect of this. But
Well, your red light is on. Can you just quickly address the Dolan-Nolan perhaps more directly?
Sure. As far as nexus is concerned, there's no, as the First Department correctly held, there's no relationship between what the Arts Fund exaction and artists' housing. And in fact, the record even says the Arts Fund is not intended to replace the loss of space for art in Soho and NoHo.
But what about their point that, yes, housing is part of what these restrictions were intended to achieve, housing for artists, but it was intended to do more than that. The reason you wanted the housing for the artists is to create a nourishing environment where artists could flourish, where artwork and the culture would flourish. And there are other ways to also achieve that beyond creating artist housing. Why isn't that enough?
I think that's kind of the argument the Supreme Court was presented with in Nolan when it came to access to the beach, because if you recall Nolan, the point of the Coastal Commission said it could deny the permit there because the house would obstruct views. And then it said, well, you can have your permit if you give us an easement. The easement didn't have anything to do with views. It had something to do with the broad concept of beach access, but it didn't have anything to do with the specific thing that the Coastal Commission actually wanted to deny the permit for. So here, the reason to deny a conversion permit, to the extent there is one, would be to preserve housing for artists. But the Arts Fund fee doesn't actually help to do that, and in fact, it's not going to be spent in Soho and NoHo anyway. And so when you add that to the fact that, as the First Department correctly held, there's no evidence of negative impacts on certified artists, and there's no externalities here to mitigate because the city wants to get rid of JLWQA, and that's the whole purpose of the rezoning, to increase residential use and to sort of get rid of this outdated industrial use compromise from 1971. And so for those reasons, I ask that you affirm the judgment of the First Department. Thank you.
Thank you.
So why isn't he correct that it's all about just increasing residential use, not really about supporting artists?
Well, I think that my friend on the other side misconstrues what the purpose of the artist restriction is in this case. He focuses on the housing piece, but that is clearly a secondary aspect of what the restriction was meant to do. If we look at MDL 275 and we look at the City Planning Commission reports and all of the reports leading up to the determination of the fee, it was about preserving the public presence of the arts. It was about ensuring that art and artists could work in the city, could make art within the city. That was the primary purpose, according to the law, under MDL 275 for this restriction. So this is nothing like Nolan.
So how does the fee achieve that goal?
So the fee achieves that goal because it can be used for grant-making purposes, for artistic programming. It can also be used for purchasing facilities, for purchasing artistic space and renovation for artistic space in the Lower Manhattan. So that directly advances the purpose.
The city could have done that before without designating housing for artists.
I think that what we have to remember, both in terms of the genesis of this restriction as well as what the city is trying to do here, was to balance competing concerns. That's a hallmark of zoning, zoning law and what the city's purposes are here. So when the artistic restriction was first conceived, it was to balance the manufacturing uses and the industrial uses and these vacant spaces that artists were using to create their art. It was not to create a housing program. It was to ensure that the community as it existed then advanced the city's needs and in terms of what the actual
Housing
community
was secondary, you
there.
just want to create an artist space, and they may live in that space also. Is that what you mean?
That's right, Your Honor. So, and then when we look at the arts fund fee, again, we see this a similar compromise here. We see that there are multiple competing interests. There are people that want to increase, expand artistic restrictions, artistic housing. There are people that want to remove it entirely. And so what the city did here, and reasonably so, was to balance those interests by establishing this fee that provided a pathway to empower property owners to decide whether they wanted to remove this restriction, but conditioning that on the mitigation of the impacts of
But
doing
you don't
so.
dispute that the arts fund fee doesn't create any artist housing, right?
No, it doesn't, and it doesn't have to, Your Honor. What it has to do, it has to advance a consistent purpose. And I would point to this court's decisions in Consumers Union and Twin Lakes. Consumers Union, there was a nonprofit insurer that was converting to for-profit. The question wasn't whether the funds there were going to be used to create another nonprofit insurer. They were going to be used to advance the purposes of the original entity. Twin Lakes, the same thing. You have a $1,500 impact fee for various development lots that could be used for broad recreational purposes, even though the
Your
concern
red
was
light is on.
parkland.
Could we just get back to Kuntz for 1 minute? And I think this discussion with your opposing counsel and Judge Halligan, I think there are things in Kuntz that can support a reading of tying it to an easement, but as I read Kuntz to the end, it seems that that holding is getting broader and broader. And I think, as you were going to say in the very beginning, way back of your presentation, one of the reasons this isn't a taking is because it's a monetary fee. It's the equivalent of a monetary fee. And I don't want to put words in your mouth, but something that along the lines of Kuntz is tied to an easement. But the holding of Kuntz at the very end is, we hold that the government's demand for property from a land use permit applicant must satisfy the requirements of Nolan Dolan when the government denies the permit and even when its demand is for money. Right? Stop. And then Justice Kagan, picking up on the possible implications, I think, of that holding, says, the majority extends Nolan and Dolan to cases in which the government conditions a permit not on the transfer of real property, but instead on the payment or expenditure of money. So clearly, Justice Kagan, dissenting from that holding, which uses broad language and is not tied to an easement, seems to suggest that Kuntz covers a monetary fee to me.
I'll acknowledge that there is some broad language in Kuntz, but I think that what's important is that the majority opinion in that case walked back its determination by emphasizing that the that the decision had nothing to do with user fees, taxes, and similar obligations. Those were still not takings under the court's analysis. So it was a response to Justice Kagan, a limitation on what the court was saying in this case, that it wasn't actually throwing out all monetary fees and saying that all of them, so long as a property owner had to pay it.
What's the line that we're, sorry, I know your light is on, but what distinguishes one from the other? I think the majority's opinion in Coons clearly suggests that there are some monetary payments which should be treated appropriately as a taking, and as you say, with the user fees, some that should not. How do we distinguish between them?
So I think we just looked at Coons' reasoning, Your Honor. I think that Coons was pretty clear on this point that what was motivating the decision there was this connection with the easement that was being demanded, the dedication. So
But
the in lieu fee-
that's not something, as I think Judge Garcia was suggesting, that is echoed in the concluding paragraph or so of the majority's opinion. So we should just read that into it or across the opinion, I take it?
Well, I think that we have to read the opinion as a whole. There's that aspect, that the concern, this anti-circumvention concern, that the government here was exacting a functional easement by tying it to this, tying the fee to this demand for a larger dedication of property. And I would just, dispute this characterization of the Florida courts. The Florida courts may have said that this was just a monetary exaction. I think Coons was very clear that it was not just
Is a monetary exaction, you would agree, right? The traffic impact fee not tied to a property interest.
There's no indication that there's tied to a property interest in
And
the
when
same
that
way.
went back to California, the mid-level appeals court found that it was a taking.
The mid-level appeals court upheld it based on it satisfying Nolan and Dolan.
So they had to get through the takings part of that first.
They did.
I think they applied Coons and said it was a taking.
They did, Your Honor. And so, I think that there is a dispute on this, certainly, but I think that that is a misreading.
And I believe that the California Supreme Court may have vacated that intermediate appellate court decision. I'm not sure. Maybe you know.
I think they disappeared it. I think they said it
They-
had no presidential value.
They unpublished it, I think, and
Whatever that means.
under California law, I think that means it cannot be cited. So, but I think that's,
Less litigants.
But it suggests there's an open question that is before us.
I think that's right to the extent that there is broad language in Coons, but I think that the Coons' reasoning and the majority's response to the dissent's assertion that this removed all monetary fees or it applied Nolan and Dolan to all monetary fees, the court pushed back on that characterization. So I think the dissent was wrong ultimately in that assessment, because Coons made very clear that there were pure monetary obligations, and left for another day what that line was going to be. And I submit, based on the court's reasoning in that case, the line is whether it is, if there's a per se taking involved. That's the determination here that was important here in terms of what the fee was doing. It was connected to this, serious infringement of property rights in terms of, dedicating a piece of land for public purposes to the government. So I think that intrusion is what was really motivating the court there, and that's why the fee looked like something different than all of the other fees.
And here,
that
there's
the
no
court
per
said.
se taking, because it's just turning over money, and if you choose not to do that, it's your choice. You keep all the rights you had before the opportunity to convert, correct?
That's
Is that-
right.
Is that the way you see it?
That's right, Your Honor. And I think that, there's no takings claim in this case. They've acknowledged that there is, or, pardon me, there's no regulatory takings claim in this case. They've acknowledged that it doesn't apply here, but that framework still could be applied in an appropriate case. It's just the same as due process, same as equal protection. Just because the Nolan-Dolan analysis doesn't apply doesn't mean that there are just nothing constraining the government's role in this. Thank you. Thank you, Your Honor.
Last case on today's calendar is People v. Shaw.
Good afternoon, Your Honors. Clea Weiss for Samuel Shaw. May I please reserve 3 minutes for rebuttal?
Yes.
Thank you. Before discussing attenuation and the voluntariness of the purported consent in this case, I'd like to start by addressing the SWAT team raid and the arrests and why my client's arrest was illegal, which the Fourth Department correctly held in this case.
Can we reach that issue?
You can. County court did render a decision on that, and the Fourth Department was correct to review that decision.
Right, but you prevailed on that decision, right, and you're appealing? So,
So we did prevail on the issue of the Fourth Amendment violation in the Fourth Department. I was starting with that because I think the nature of the Fourth Amendment violation does inform the rest of the analysis. But
but do you think we can revisit the Payton determination below?
I think it's a mixed question of law and fact, and I think that there's record support for the Fourth Department's determination that Mr. Shaw was forced out of his house, therefore violating Payton.
So that sounds like a no in terms of our review.
I think this court should also find that there's a Fourth Amendment violation in this case, and I think that there are no impediments to this court's review.
I guess
of
Judge
that issue.
Garcia's question really is, you're not aggrieved by that part of the decision, right? And if you're not aggrieved, then, you would have to have a cross appeal for us to be able to reach the issue, which you don't, so we're stuck with that ruling, so you can move on if you like, I think, is what he's
And I
suggesting.
will.
Okay.
I know Mr. McCarthy
he was
does
arguing.
take issue with the Fourth Department even adjudicating that claim, but I think the Fourth Department was correct because county court did render a reviewable decision. And given that there is a Fourth Amendment violation, in this case, the main issue for me is that the people have never argued an exception to the exclusionary rule in this case. And this court has held that exceptions to the exclusionary rule, such as inevitable discovery, have to be argued and they have to be proven by the people. And in this case, Mr. Shaw in his motion papers identified the firearm as an unattenuated fruit of his illegal arrest. It's twice in his motion papers.
Yeah, but what the people are relying on is a voluntary consent, and they're basically saying that, for lack of a better word, trumps what was going on in terms of attenuation.
So I disagree with that because I think the case law makes clear, including this court's cases in Borges and Leroy M., that it has to be voluntary and it has to be attenuated. There's two separate analyses that have to be satisfied.
But it seems to me the appellate division, when I read their opinion and their cite to their other appellate division case, is saying a voluntary consent by a third party is per se attenuation in this case.
So I disagree with that, and I think that this court's
But
decision...
you disagree that they said that, or you disagree with the premise?
I disagree with their premise.
Right.
Yes, that is what the Fourth Department in this case held, that a voluntary
But it
consent...
seems to me that attenuation goes to what you were talking about first, which is fruit of the poisonous tree. And if I'm subject to an illegal arrest, the defendant subject to an illegal arrest, Payton violation, and that defendant gives consent, even if that consent is voluntary, it has to be attenuated from the Payton violation in order to sever that. This is a third party consenting. So why isn't the appellate division correct that voluntary consent, which the voluntariness may take into account the facts and circumstances of the Payton arrest as it affects a voluntariness, but why do you need a separate attenuation?
So a third party's consent can be a fruit of the defendant's, of a Fourth Amendment violation against the defendant. And we see that...
Why?
Because coming from Wong Sun directly, in which there's three
No, but
defendants
what
in
is
Wong
the
Sun...
logic in terms of fruit of the poisonous tree and suppression of having a third party consent be subject to that?
Because the law enforcement choosing to seek consent from a third party, which in these cases is often the wife or the girlfriend or the sister, is very much a part of the entire strategy, an entire law enforcement strategy of going to a home and seeking to arrest
Let's say
somebody
it was
at
a
their home.
different home, right? They do an illegal Payton arrest at this residence, and they simultaneously go to the defendant's other residence, and they get a roommate consent. Is that roommate's consent in residence 2 subject to attenuation from the Payton violation?
So I think it is, and in my brief, I cite State versus Lane, which is the
So
decision...
how would you analyze attenuation in my hypothetical?
So I would, in State versus Lane, the Iowa Supreme Court, I find it to be a very thorough and persuasive opinion. In that case, the defendant is legally arrested at his neighbor's garage, and they go to down the street to his house where his girlfriend is present, and they seek consent from the girlfriend to search his house. And the Iowa Supreme Court goes on to analyze whether her consent is a fruit of the illegal arrest.
And how do they do that?
By looking at by applying the normal factors from Brown versus Illinois. The exact same attenuation
So
factors.
how much time it is between, let's assume she doesn't know, I don't know the facts of that case, but let's assume she doesn't know about the arrest at all. So you would still look at how close in time it was to the arrest that she knows nothing about?
So temporal proximity in that case would be perhaps a less important factor. but
What
you
are the
would-
important ones?
Sorry,
What are the important factors regarding attenuation in that circumstance?
intervening circumstances, the flagrancy of the police conduct.
All
the
happening
fact-
at another place?
Well, in a case where there is a Fourth Amendment violation at one location and the officers go to a second location to seek consent, I think it is the people would have a strong argument that there is attenuation. These
So if-
factors go to,
Go ahead.
the factors go, I think, to the analysis and that there might be a strong claim for the people that there is attenuation, but they do not say that there is per se.
So any investigative step they take at the same time they do a patent violation is subject to an attenuation analysis?
Anything that is a fruit of that patent violation or that.
So where,
That's circular, I think. We're
Yeah.
trying to figure out what the fruit is.
So when the
What's
def-
properly deemed a fruit.
The defendant claims something is the fruit of the arrest. That shifts the burden to the people under Borges.
Right, but where you have third-party consent, I understand that general proposition, but where you have third-party consent, are you saying that that framework doesn't shift at all? We consider it exactly the same?
I think that framework does not shift at all, and there are numerous federal courts of appeals and state courts that have held that it is the same analysis.
But why should that be, as a matter of logic? Why doesn't the fact that there is another actor involved somehow perhaps mitigate the attenuation concerns a little bit?
Having another actor involved does not per se take us out of an attenuation analysis. It does
I
affect
take that
it.
point, I'm just asking you whether it makes it, for example, easier for the people to show there was attenuation.
I think it would make it easier for the people to show attenuation when it is a third party.
Just to shift gears for a minute on voluntariness, I take it your argument is there's no record support for voluntariness findings. Okay, so in light of her testimony, how could that be the case? She testifies in a way that I think could perhaps be read to suggest that there's voluntary consent.
So her testimony is that she was not coerced into consenting and that she was not promised anything.
And not intimidated, I think she said, if I'm remembering the record correctly.
That's correct. And those three things, taking her testimony at face value and crediting it, those three things are not inconsistent with caving to overwhelming official pressure.
Yeah, but if the question is record support, then whether it's consistent or inconsistent may not get you across that line, right?
It may not, but I do think that this court could hold as a matter of law that when somebody has been subjected to a patent violation, handcuffed and removed from their own home, and while that Fourth Amendment violation is still ongoing because she's still in the car handcuffed when they elicit the consent from her.
No matter what the individual says under oath.
Right, when
About their reaction.
when you've been subject to a stressful patent violation removed from your own home, that the consent to search
Yeah,
your
but
own home.
usually in those circumstances, that witness would be testifying for the defense to say that she felt coerced. I mean, in this case, she's testifying for the people and saying she didn't feel intimidated. That plus the testimony of the police officer who basically said she leapt for whatever, I don't know what he said, something like that, leapt for joy or hugged him or was happy that they would get a gun out of her house, and she was distressed when she found out that it was her friends who were murdered. I mean, how can we say that there's not record support for the court in those circumstances? She's testifying for the people and saying, no, it was voluntary.
You know, and I do recognize it's a mixed question of law and fact, and that is a difficult burden, but I think this court could, I think it would be an appropriate rule to hold as a matter of law that consent cannot be voluntary when you are giving consent to search the location out of which you've just been illegally removed.
And are you aware of other kinds of circumstances where we have held, I mean, usually it's a fact-specific analysis, right? You look at the record in front of you, and I hear you to be suggesting a blanket rule which says, you know, when a third party witnesses a patent violation per se cannot be voluntary no matter what they experience or say they experience. So where else have we taken a bright line view like that? It seems unusual to me.
I think it would be, in the context of voluntariness, I'm not sure that this court has ever held something similar. So I understand that on that point, that would be a novel rule we'd be asking for this, from this court. But returning to the idea that the people's burden is both attenuation and voluntariness, putting aside voluntariness, which may be a mixed question of law and fact for which this court might find record support, that still leaves us with attenuation, which the people have not preserved. And they've not preserved it, nor do I think they could win on the merits, because it's that Ms. McCoy's consent is also a fruit of the patent violation. The search is illegal for that independently.
So
for that
regardless
reason.
of whether she was in handcuffs or not, your position is still that that consent was not properly attenuated from the illegal arrest of of your client?
That's correct, yes.
So the circumstances of the consent really have nothing to do with this, in your view?
Because I think looking at attenuation, and again, it's my position that the people have not preserved this contention, but when you look at attenuation, you are measuring from the Fourth Amendment violation to the consent itself. And I think that this is a really important issue because this court has said it both ways in different cases. In Banks, this court concludes, it concludes and analyzes the attenuation from violation to consent. But in matter of Leroy M. and Borges, the court considers the nature of the consent in that analysis. And in People versus Lane, there's an extended discussion of this, and I think there's also in footnote 3 of that decision, the court is analyzing the 10th Circuit Court of Appeals, which, like this court, had had opinions analyzing attenuation in both ways. And the 10th Circuit corrects itself and in an eventual opinion and says, we want to clarify our former holdings and note that we measure between the violation and the consent itself. And I think that this court also has cases that analyze attenuation in both ways, and this case would be an appropriate case to clarify that what we look at is what is attenuate from the violation to the giving of the consent, and the nature of the consent actually doesn't come into that determination. And the reason for that is that when you're looking at the evidence that's seized, it is not different from the consent, which is the search, giving consent to do the search that gets that evidence.
I think in Lane, and I'm looking at page 386, the court is saying, thus, if the circumstances show the initial questioning, or in this case, the consent, was given with detached reflection and a desire to be cooperative, it indicates the presence of intervening circumstances that break the causal chain. So why isn't that what happened here?
So in Lane, what the Supreme Court of Iowa ultimately concludes is that they only want to look at, they're measuring the girlfriend's consent in their separate home, whether it's attenuated from the violation. And they do look at the nature of her consent in their voluntariness analysis, which they do separately. But as to the attenuation analysis, they do stop it upon the asking for consent, is my recollection of that case.
It sounds like you're saying attenuation analysis in this type of circumstance and maybe anything other than the one that was the subject of the prior hypothetical is really just time dependent, or is it more than time?
It's more than time. It looks at the Brown versus Illinois factors of temporal proximity, intervening circumstances, and flagrancy and purpose of the police conduct.
Okay, so if we have intervening circumstances such as, new information about the crime that took place, the shooting that took place, which suggests a different motivation for the consent, would that be the proper subject of an attenuation analysis, or does that go to the consent?
I think it can be considered, and that could be weighed against the fact that she's still handcuffed in the back of a police car. Lieutenant Zenilovich testifies she's not free to leave, so she's illegally detained. I think that...
Do you think the record's clear on that? That is she handcuffed at the time of consent? I thought the record was ambiguous on that question.
Her testimony is clear that she's still handcuffed in the car at that time, and that after she gives consent is when they let her come out of the car, and they unhandcuff her in order for her to sign that form.
So you read it as her giving verbal consent in the car and then being uncuffed to sign the form outside the car?
I think that's established by her testimony. Thank you.
Thank you.
Good afternoon. Marty McCarthy for the People. The question of Peyton is unpreserved for this court's review.
Can I ask you to start by telling us your response to the argument about whether you preserved attenuation, and if so, how and where?
To answer that question, I would have to talk about Peyton.
Okay.
And the reason why there is no discussion of attenuation at the hearing level is the hearing court summarily denied the Peyton motion. It noted that there were insufficient allegations in its written
That's right,
decision.
but were there papers put in?
I'm sorry.
Were there papers that were filed? Or
You
what-
mean defense
Yes.
files their omnibus motion?
Right.
The omnibus motion sought, they sought to litigate the issue of Peyton.
Yes.
Their argument in the omnibus motion was he was arrested inside the house.
But presumably, you could have raised attenuation in your response papers or before the court, I assume. Why should you not have put that in?
So let me answer for myself. I'll answer first for the prosecutor, and I'll answer for myself. The allegations in defense motion was he was arrested inside the house. The prosecutor said, no, he wasn't. He was arrested outside the house. Had the defendant made the motion in his motion papers that he was constructively arrested inside his house, then the prosecutor would have been triggered to say, assuming that to be true, then the fruits of this, of the any legal evidence were attenuated from the illegality of that
So
search.
your argument is that it wasn't presented and therefore you raised it at the first possible time?
Correct, and when you looked at it, when you look at it as sort of as an academic question, the defendant's arguing now, the defendant argued at the Fourth Department, and the defendant arguing now that he was constructively arrested inside the house. Had he litigated that issue, then yeah, we would have been prompted to say, okay, well, that conceivably could be true, then we're going to argue
So
attenuation.
constructive arrest in the house wasn't raised at the hearing either?
It was raised in the motion. The judge, prior to the beginning of the hearing, said the purposes of this hearing are to litigate issues of standing and suppression.
Wait, I thought you said that the original motion was strictly based on that he was arrested in the house.
Correct.
And that constructive arrest wasn't part of the argument.
Correct. But there was also, they also raised the issue that he had standing to challenge the search of the premises. So you can theoretically, let's say none of that stuff happened with respect to let's say there was just one police officer standing on the threshold, knocks on the door, defendant walks out, he gets arrested. So no Peyton violation, period. Theoretically, he can assert standing for the search of the house. So those are
He
two
could challenge the
separate-
voluntariness of the consent. Right.
Correct. And so those theoretically are two separate questions. They become related had he been arrested inside the house. But when the issue was presented to the hearing court looked at the allegations in the motion papers and simply made the determination these were insufficient. We're only going to litigate the issue whether you had standing to contest the search of the house and the propriety of the search in the
So
house
to
and
my
the voluntariness
question,
of the consent.
the issue of constructive arrest in the house was not litigated at the hearing.
It wasn't in the motion papers. The judge, I'm going to answer that, I promise you. It wasn't in the motion papers. The judge limited the scope of the hearing. The defendant started making arguments during the hearing, but the written decision said that was summarily denied. So not only was it not raised in the motion papers, although it was litigated at the hearing, the court's decision said that had been summarily denied.
On the papers, right, to make
Yes.
sure I'm looking at the right piece of paper, I'm looking at defendant's renewed motion dated April 26, 2019. It's page 144 of the record, I think. Okay. And so paragraph 43 says, on information and belief, gives the date, officers ordered the defendant to exit his temporary domicile and arrested him. That suggests to me that's a constructive arrest allegation, no?
But then they went on to say he was arrested inside I believe they then say that he was arrested inside the house. So,
But what I just read to you does suggest constructive arrest, doesn't it? Paragraph 43?
Only if only in that scenario, only if he did walk out, but I
It
believe.
says, ordered the defendant to exit his temporary domicile and arrested him.
But then they then allege he was arrested inside the house. I believe it's the following page on 145. And if I'm wrong, I apologize.
Well, paragraph 49 says the defendant's warrantless arrest within his home was in violation of his patent rights. I'm paraphrasing there. I guess you'd have to read warrantless arrest within his home as meaning literally within his home and not as instead, shorthand for what a patent violation is, including a constructive arrest.
But that's what the hearing court read. So even assuming,
Well, the hearing court presumably read paragraph 43 also.
yes, and even assuming if that was enough for him to put the issue in question, the hearing court did not grant the hearing. So the relief that was required at the appellate division was not to litigate the issue, it was to remand.
Right, but you filed a response on May 3rd, right?
Correct.
And presumably, if you understood the defendant to be putting a constructive arrest at issue, you could have, and I would guess maybe would have, raised an attenuation argument, yes?
Presuming that, and I was not the prosecutor.
I didn't mean
No,
you
and
particularly, I mean the office.
Yes, I appreciate that. But I am assuming that the prosecutor didn't read it that way either. He read it the same way as the court did, which
Okay.
is why the court summarily denied it. So even if the defendant put it in issue, the remedy is not for the court. The remedy wasn't for the appellate division to decide it. The remedy for this court's not for this court to decide it. The remedy was a remittal for a hearing on whether he was arrested inside the house, and that didn't happen. That wasn't what the defendant sought at the appellate division, and it's not what the defendant is seeking here. So that's really, when we talk about attenuation, that's why it's, yes, I didn't argue, the prosecutor didn't argue attenuation in the motion. I didn't argue attenuation at the appellate division either. The appellate division
can I
reached
ask-
this question in its interest of justice jurisdiction, which is greater than yours.
Right.
Presumably.
On the appellate division, it looked to me like perhaps the appellate division maybe transposed the standards for voluntariness and attenuation. It said that it was analyzing and deciding that the consent was voluntary, but it looks to me like the factors that were applied were the ones that were outlined in Borges regarding attenuation, not the Gonzalez factors on voluntariness.
And I believe that's what the dissent pointed out
Yes,
as
so-
well. that-
So what do we make of that? Why isn't that something that we should send back for them to sort out so that there's a voluntariness determination that's made pursuant to the proper factors?
Ultimately, you can always begin with the trial court, because that's where your jurisdiction emanates from. Trial court did decide voluntariness on the correct factors.
But I take it you're not disagreeing with the dissent's characterization of the analysis that in the majority opinion?
It seemed confusing to me, and I will admit that. It was confusing to me, because it was also, and after the decision was made, and then there was leave, it was apparent to me that the court shouldn't have decided the issue of attenuation at all, or the issue of patent at all, because of that. And so I would say that that decision is very confusing for a number of reasons. So, but in terms of attenuation, do you want to talk about attenuation? Because that's kind of how this all started, and I wanted to make sure I did answer that question
Sure.
ultimately. So there was a discussion about third-party consent, right? And I would point the court, as I did in my brief, to the Fernandez case in the Supreme Court. Someone who is not the subject of the police action, which is the homeowner or the apartment owner in this case, should be free to give consent, regardless of whether there is some sort of patent violation with somebody else, in this case the defendant, because they want to get dangerous contraband out of their home, or they don't want to be associated with somebody who's subject of criminal activity. And as just
Well, why can't those be examined under, sorry. right in
Well, there
front of
you are.
Yes, here I am.
Sorry.
Why can't those be examined under a attenuation analysis? Those factors?
I don't think that I'm going to say this negatively, I mean it positively. I think you can, right? I think you can do it. But I think that desire is a big intervening factor. And to me, it's an outcome determinative intervening factor that this particular individual who had very little connection to the defendant, and I talked about standing. I imagine you probably don't want to talk about standing. It's in my brief. No one's brought up standing. I'm not going to bring up standing. That being said, when you look at the relationship between these two people, this isn't a boyfriend-girlfriend. This isn't a husband-wife. This isn't father-son or mother-daughter. These are casual acquaintances.
It sounds like you're, in addition to responding yes, going through the factors of attenuation.
I'm sorry?
Are you going through the factors of
Yes,
attenuation
I'm
or
going-
voluntariness?
I'm going to go to the factors of attenuation and voluntariness. So I guess,
I mean, but do those have to be connected? Why can't they exist on parallel terms, attenuation and voluntariness? And why can't the appellate division decide that they're going to decide this case on voluntariness? I'm going to push back on you a little bit on that, because I think the AD said, I'm reading from 1185, the tenant testified for the prosecution she voluntarily consented to the search out of a desire to have the gun removed. The tenant never claimed that her consent to search was anything but voluntary. We reject defendant's contention that the tenant's testimony is unworthy of belief. We thus conclude that the court properly refused to suppress the gun. So I feel like they're deciding this on voluntariness. Do you disagree with your colleague's assertion that Borges says you have to do both? It's a two-part test, attenuation and voluntariness, or can you just decide this case on voluntariness?
only if and that was one of the other issues that I don't think is preserved, because the argument that the consent was procured as a result of the patent violation isn't accurate, because the consent didn't come from the defendant. The consent came from the third party. So I think you can only look at it in terms of voluntariness and not attenuation, because you don't have that scenario. You don't have the scenario.
There are a number of federal cases I saw which, without a whole lot of analysis, but which treat a patent violation as to a defendant as having equal force with regard to some third party who's providing consent. You know, usually somebody else who is in the house. So why is that not correct? Why do you say that it's only voluntariness and not attenuation because of the third party component here?
Well, because of the fact that when a defendant is making a motion and arguing for the illegality of something, he can only assert his own constitutional violations. He cannot assert a third party's constitutional violations.
Well, I'm not sure that, you know, a third party could make a claim as to a patent violation as to them. I think the question is, you know, what flows from a patent violation as to the defendant.
Correct, but that's my point. Like, how can...
But why doesn't it, I guess, is what I'm asking.
Because a defendant can't assert the constitutional, and I think I said this already, so I apologize. A defendant can't assert, because the defendant can't assert the constitutional violations of a third party, then any third party's...
So the federal cases that treat it differently are wrongly decided?
I would say without more in-depth analysis or guidance from the Supreme Court, I would have to say that that they should be treated differently.
Just shifting gears for a minute, can I ask if we were to disagree with you and conclude, you know, at the end of whatever analysis that the gun should have been suppressed? I read your briefs as not suggesting that as to the CPW count specifically, that there's a harmlessness error. Am I right about that?
So there were nine total counts for which he
Yes.
was convicted. The last count 9,
Yeah.
related to his possession of the
That's the
firearm.
CPW count, yes.
Yes,
Yeah.
CPW on the date of the
Yes.
search. That one clearly is not harmless error.
I understand you're arguing harmlessness as to the others, but not as to that specific one.
Certainly not, because
Thank you.
again, that was the primary and only evidence of possession of the weapon that particular day. So if I'm wrong on, I guess, everything in that scenario, and in terms of your harmless error analysis, the rest of the counts, because the rest of the counts pertain to the two murder ones, and the criminal possession, the assault one and the criminal possession of a weapon occurring on the day of the shooting, there's more than ample proof absent the gun of those. And if there are no other questions, my time is up.
Thank you.
I'd like to also address harmlessness, but before getting there, I want to just dig into the record a little bit to talk about what's presented in this case and why the people's failure to argue attenuation becomes determinative. Besides paragraph 43 from the renewed motion, looking at the argument after the hearing, it starts with, on page 711 to 712 of the appendix, defense counsel's oral summation saying it wasn't optional that Mr. Shaw leave the residence, he didn't walk out there, our RPD didn't ask politely, and that's an arrest under Payton. That's where the defendant starts. The people respond to that on the merits. In the people's post-hearing argument, they do not say, Your Honor, there was no Payton hearing. Instead, they argue it on the merits, and they waive that issue. Specifically,
You're at 711 to 712 of the record?
that's defense counsel's argument. And then looking at the people's argument, going to page 718, the trial ADA says, the testimony that you have is credible. He voluntarily walked out. Was it in response to being ordered out? Perhaps. Was it a bad choice for him? Perhaps. Does that mean there's a Payton issue? There does not. So the people responded to the Payton, the constructive Payton violation on the merits, and I think they waived their contention through that argument that this wasn't decided by the trial court. And then I do want to focus on something that I didn't highlight in my brief, and that's on page 720 of the appendix. It's defense counsel's rebuttal to the people's argument.
But counsel, I'm sorry, if they waived an attenuation argument at the hearing court and the appellate division reached it, they can do that, right? The appellate division could reach an attenuation argument, no?
They cannot, not where the people have not preserved the issue.
They can never reach it?
No, it was unpreserved. It was undecided by the trial court, and because it's unpreserved, there is nothing to remit for under LaFontaine. And that's why I think if this court agrees there's a Fourth Amendment violation, and if this court agrees that the people failed to preserve an exception to the exclusionary rule, the next inquiry is simply harmless error.
Do you want to address your adversary's argument that attenuation doesn't apply because of the third-party aspect?
I think that that's a novel rule that people are advocating, that just per se a third party's consent can never be considered under an attenuation analysis.
But do you think our cases have clearly sorted that out, or is that not something we've explored?
No, I think that's I'm going to pronounce this wrong, but Xochimilco, People versus Xochimilco, is a grandmother at the front door stepping back to consent, and that was more voluntariness, but that's a third-party consent. And then in Banks, of course, you've got two men in a car. There's a traffic infraction, a traffic stop, and they are both seized during that traffic stop, and the defendant can object under attenuation grounds as to the driver's consent.
Still struggling with how that affects the fruit of the poisonous tree argument. Because, again, you see it with the defendant who makes a statement or gives consent, and you have to attenuate that from the violation that he's suffered. And it seems like we're merging standing here with an attenuation analysis, because he is standing clearly, it's been decided, to challenge this. But there's voluntary consent given by someone else, and to the extent that consent is affected by the Payton violation in terms of the facts, I understand that. You know, it was handcuffed, I saw this person arrested in front of me and it taken from my house. All that to me would go to, was it a voluntary consent? But I understand what line in the fruit of the poisonous tree analysis we're trying to sever here. Because, yes, you have standing to challenge it, but it isn't the fruit of your illegal arrest.
So I think where I would disagree is I think it often is the fruit of the illegal arrest, because part of the attenuation analysis is purpose and flagrancy. And what we see with law enforcement is that they're often affecting an arrest and purposefully going to someone else, purposefully the girlfriend, the wife, or the sister, in order to get that consent. So it is because it's part of the law enforcement strategy.
You said it would apply to a separate house down the block, that the person doesn't even know the arrest is going on.
And, you know, the federal circuit courts, State versus Lane, and other state courts have done this analysis, and I think that it's like evidence. It doesn't go to admissibility, it goes to weight. The people would like to turn it into a per se standing rule.
But I thought they've only done that in a circumstance where they're in the same place.
That this court has only done that where.
No, are there other courts, I know your light's on, I'll stop, but are there other courts that have said where you have a defendant and a third party in different places, that there's an attenuation analysis that has any meaningful teeth there?
Other than Iowa, I think you mentioned Iowa.
I think the Second Circuit's decision in United States versus, it's not Snipe, Valentine, where a defendant is illegally arrested on the street close by to the entrance to his apartment, and the police go up the stairs to the apartment and they elicit consent from the wife who's up there.
That's the same location, right? I mean, the same.
I mean, he was arrested on the street, so it is a close location, but it is not the same location.
Does the wife know about the arrest?
I believe in Valentine, the wife is aware of the arrest at that point, and the Second Circuit in the Valentine decision actually remits. They say we need to analyze attenuation, and they remit for that consideration. They don't decide it themselves. I'll touch briefly on harmlessness, just to say that a homicide prosecution where there's a murder weapon in evidence is a lot different from a homicide prosecution where there's not a murder weapon in evidence. The people set up their trial strategy to emphasize the forensic evidence in this case. Mr. Hopful was the last witness, and he came in and testified that he had identified that these bullets recovered at the scene were fired from the gun.
But with respect to harmlessness, you do consider what the other evidence was or wasn't, correct?
Absolutely. I think that there's just a reasonable possibility of a different verdict in this
You've got
case.
the two eyewitnesses, you've got, if I'm remembering correctly, the print, and you've got the casings, the print on the magazine from a different location, and the casings from the bullets.
But the casings from the bullets lose evidentiary value when the weapon itself is not in evidence, because they're just casings at that point. And, you know, while I don't think there's overwhelming
I'm
evidence,
misremembering the record, there's not a fingerprint of his on the casing?
there is a palm print on a magazine left at the scene. You know, and even if
That's the
this
magazine, yeah.
court determined that the evidence was overwhelming, kind of reaching the second step in harmlessness, there's a reasonable possibility that a jury, without the murder weapon in evidence, without all that supporting forensic evidence that showed that this, as the people argued in their closing, this was the weapon that committed the murders at 670 Thurston, that is powerful. That's powerful evidence for a jury, and without it, I don't think you could say that we'd have the same
Even
verdict.
with identification evidence? Eyewitness identification?
So there are two eyewitnesses in this case, and you know, when those eyewitnesses are corroborated by strong forensic evidence, it's pretty hard to attack them. But they're not the strongest eyewitnesses. They're not the weakest eyewitnesses. I would concede that.
Didn't one say she knew him for a period?
She was familiar with him from the neighborhood. But again, with that witness's testimony, she has just suffered a traumatic injury when she sees him, and not questioning her credibility, but simply her ability to recall what was happening in that moment. A lot of her testimony was inconsistent, saying that he was in front of her when the evidence showed that he would have been to the side of her. So an eyewitness like her, defense counsel.
Whether she knew him would be the dispositive and could identify him as the perpetrator of the harm that she suffered was for the jury to determine. And if she said she knew him as opposed to she'd never seen him before, those are factors for the fact finder, right?
Certainly, and I just think that
And there's another witness.
the credibility of both Mr. White and Ms. Nunez was really more up for grabs in a trial where their testimony is not corroborated by very strong forensic evidence. And that's why I think that though there's two eyewitnesses and there's the palm print.
The palm print doesn't put him at the scene?
It doesn't,
Connecting him to a weapon?
it's difficult evidence, but I think that still taking the murder weapon out of this prosecution, just answering the question, is it a constitutional harmless error? So is there a reasonable possibility that this affected the jury's verdict? And I think when you take the murder weapon away from a homicide prosecution, there is a reasonable possibility.
Thank you.
Thank you.
Mr. Keister, if you and your class would like to say, totally up to you, I'd be happy to come talk with you for a few minutes, but if you have to go, I understand too.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this court time, this court now stands adjourned.